Call this meeting of the Judiciary Committee to order. Members, take your seats. A chair recognizes a quorum. Today we've got 11 bills on the agenda. I'm not going to go through all of them, but the first bill up is going to be Representative Mann, House. Oh yeah, we can do the minutes. You didn't have that on here, so. Okay, what minutes from where? Oh, there we go. Okay, we've got the minutes of March 21st. Representative Barr moves the minutes of March 21st. Any discussion? Seeing none, all in favor say aye. Aye. All opposed say no. Motion passes 1-0. The minutes of March 21st are approved. Representative Mann, welcome to the committee. You have House File 557. This is prohibiting non-compete agreements for physicians. It's had two other hearings in HHS policy and in labor. And the motion on this, the chair will move that House File 557 be recommended to be placed on the general register. Representative Mann, to your bill.
Thank you, Mr. Chair, members. Good morning. Today we're talking about HF 557, which would, like the chair said, restrict non-compete agreements in physician contracts. So what's currently happening is that most physicians in their contracts have a non-compete clause. And what this means is that when your employment ends at a clinic or a hospital or any organization, you are not allowed to practice medicine in a pick a number and pick a mile radius from your previous employment. So if a provider, for whatever reason, wants to leave their practice, they have to sometimes relocate their entire families in order to continue practicing medicine, even if the clinic down the street is hiring. And the biggest problem with this is that it impacts the physician-patient relationship, where doctors are no longer allowed to see their patients, and their patients have to find a new doctor. This clause is a direct barrier to good patient care. It is a direct barrier to continuity of care, which we have seen and we know that improves health outcomes. This is one of those contractual clauses that is there solely for the benefit of the organization, and it is not in the best interest of the physician or the patient. There are many, many barriers to good patient care, and this just does not have to be one of them.
Excellent. Thank you, Representative Mann. Why don't we go to testifiers? Raise your hand if you're here to testify on House File 557. One, two. I see two hands up. Two guys in dark suits on the right side. Anyone else? I'm not seeing. Okay, come on down. Did you have any of your testifiers, Representative Mann? No. Okay. Welcome to the committee. Please identify yourself for the record and begin your testimony.
Thank you. My name is Ben Peltier. I'm the Vice President of Legal and Federal Affairs for the Minnesota Hospital Association. Before that, I spent several years working as a transactional attorney in the General Counsel's office of a large Minnesota health system, where I negotiated and was involved in working on dozens and dozens and dozens of physician contracts that involve clinic acquisitions, employment arrangements, other sorts of PSAs. MHA represents 141 hospitals and health systems in the state of Minnesota, and we employ thousands of physicians here. And the percentage of physicians that are employed by our health systems is growing. Health system employment is a very attractive option for physicians. It provides them with less financial risk, less administrative burden, more resources for staffing, technology, all these kinds of things. And non-competes are actually quite popular with many physicians. They give the hospital systems the ability to provide physicians with additional compensation, additional consideration. By law, every non-compete agreement has to be attached to some sort of additional compensation through the consideration. These clinic acquisitions, employment arrangements, PSAs, all of these kinds of things are possible because hospital systems are able to make investments based on a long-term plan for support and the physician participation. Without some assurances that the system cannot, the health system can make these can recover their investments, they are not going to have the ability to make these investments long term, and will have to operate in a different way. This legislation would make us in Minnesota a bit of an outlier. Physicians would be the only professionals in the state that wouldn't be able to enter into non-compete agreements. And very few other states have tried these sort of significant restrictions that are in place. And it's really important to remember here that the physicians, they're not helpless victims here. They benefit from these employment models. No physician is ever required to enter into a non-compete agreement. No physician is required to go to work for a health system in the state of Minnesota. And Minnesota law really currently protects these physicians and anybody who enters into these non-compete agreements. As I mentioned, there is the requirements for additional consideration. In addition to that, courts look at the nature of the employment, the extent of the business, the time frame of the restrictions, and the territory that are covered, and to make sure that these agreements are reasonable when they're challenged. And if they're not reasonable, Minnesota has adopted this blue pencil doctrine, which is very common, which we all learned about in law school, that allows the court to make modifications to these proposals to make when they are unreasonable, when the non-compete is unreasonable. In closing, I just would say that the legislation is overbroad, would put severe restrictions on the ability of physicians to enter into types of legal arrangements that they seem to increasingly prefer to enter into, and I would recommend that the committee reject the proposal.
Thank you, Mr. Peltier. Stick around if members have questions. Next person, come on up. Please introduce yourself for the record. Begin your testimony. Members, keep in mind that we have 11 bills on the calendar today. We are going to be going until 12:30, but I am going to be limiting if people are going on like that, too. Some might cut you off. So please introduce yourself for the record. Begin your testimony.
Thank you, Mr. Chair. Members, my name is Santo Cruz on behalf of CentraCare Health. I would like to explain why this bill will hurt rural Minnesota, because it is counterintuitive. I think there's very good intentions behind the bill of preserving a very sacred relation between a doctor and their patient. I believe many of you received an email from Dr. Cindy Firkham-Smith, who herself has a non-compete and is a proponent of non-competes, and is also the CEO of Caris Health out of Wilmer, Minnesota. In that email, and I won't go through it for sake of time for the chair's recent comment, she describes what I will boil down to is a detrimental reliance claim. And for, again, going back to the law school days, all of you know that detrimental reliance is a way to say that when you rely upon someone's promise that they're going to do something, even if it's for a certain period of time, and you outlay huge investments in terms of perhaps forgiving tuition debt or paying off tuition debt, building $1 million facility in order to satisfy an orthopedic surgeon, or you name it, you have detrimentally relied upon the promise that that person will fulfill their promise, that they will serve in a capacity that makes that investment not just worthwhile to that practice group, but actually, as in rural Minnesota, many of the things that rural Minnesota needs, as we do our community health needs assessment, are things like tobacco cessation treatment, rural mental health treatment, substance abuse disorder treatment, and a lot of population health work that CentraCare and Caris invest hugely in. We do primary care in the jails. We have a child advocacy center. We are part of many community programs and services that do not self-sustain. Those of you who have looked at the demographics know that rural Minnesota is on average demographically older, poorer, and sicker than our metro counterparts. This means that cross-subsidization is not a dirty word in rural Minnesota. When we lay out an investment for a candidate and say we will do this and we will purchase the separate consideration of a non-compete, what we are saying is we are relying upon our detriment to put these types of resources out there in order to serve many other areas.
You could wrap it up, please. Thank you.
I would wrap it up now in respect to the chair.
Excellent. Thank you. Is there anyone else in the audience who's here? And we're going to go to questions. Folks may have questions for you, Mr. Cruz or Mr. Peltier or the author. Anyone else in the audience who is here and wishes to be heard on House File 557? Seeing none, then questions from members. Representative Barr.
Thank you, Mr. Chair. Is that Mr. Cruz, the last testifier?
Here's Mr. Cruz, yeah.
So my question for Mr. Cruz is, since you're the rural kind of doctor, representative, hospitals, but you kept talking about the rural aspect. Could you tell me how big a tool, or what kind of tool is the non-compete clause for getting doctors to practice or set up practice in a rural hospital? I mean, is that a major tool for recruiting doctors out to your area, out to rural hospitals?
Mr. Cruz.
Mr. Chair and members, absolutely. In terms of, I think Dr. Ferguson sent an email to every member of the community talking about how she's recruiting for every single specialty, and it can take tens of thousands of dollars in investment just in recruiting. And then often, as she described at the Labor Committee, she has to do more than the Metro counterparts would do in order to induce that person to come and serve rural Minnesota.
Representative Barr.
Thank you, Mr. Chair. So when you have the non-compete clause in the rural hospital, if we eliminate the non-compete clause, what do you have left for recruiting tools to get doctors, to come out to your rural hospital? Is it just the fishing, or?
Other than just paying them properly. Go ahead, Mr. Cruz.
Mr. Chair and members, I would say around paying them properly, you can't just pay someone properly and expect a non-compete because, again, it has to have separate consideration. In addition, I would note that what this bill says to courts under the reasonable person standard is that it is never reasonable. Well, the scenario I've described of putting $1 million out for an orthopedic surgery unit is never reasonable to expect that either you would be made whole on the way out 6 months later, or that person would fulfill their promise of working there for a certain period of time to cross-subsidize other services.
Thank you. Representative Barr, one more question.
Thank you, Mr. Chair. And more of a comment than anything else, because if I understand this correctly, the courts have already ruled multiple times that if a non-compete clause is way lopsided, they'll dismiss it and it's invalidated. So I'm kind of trying to figure out if the courts have already ruled why we need this.
Well, thank you, Representative Barr. I have one question in light of that for Mr. Cruz. How often when a non-compete is litigated, is it modified by the courts?
Mr. Chair, I don't have that information.
Okay. Well, the question relates to whether or not you're drafting your non-competes way too broadly. Are you? And you're going to say no, but...
No, Mr. Chair, what I would say is that what this bill does says it's never reasonable. So it's not, my position doesn't have to be that there can be an unreasonable non-compete, that courts shouldn't follow blue pencil doctrine. What I'm saying is that what this tells the court is you don't get to apply that standard anymore. There is no such thing as a reasonable non-compete. This is basically a cut and paste of Massachusetts law. There's some very interesting cases of how that's been interpreted.
Okay, well, thank you, Mr. Cruz. But normally when that happens, you think there is a reasonable parameters, and you get someone to come in to offer an amendment to what you think is reasonable parameters. But
Mr. Chair, members, we have attempted to do that. They've not been received
you
well.
can get anyone on. No, you don't get the author to offer an amendment to your own bill. You get someone else to offer it in committee. But whatever the case, Representative Scott.
Thank you, Mr. Chair. And, I know that we have a full agenda here, and there's a lot of people that have come here today for this hearing, and we haven't met for the last 2 days during our normal committee time. So I think we need to take these bills very seriously and allow ample time for testifiers and not cut them off, and allow ample questioning by the members of this committee. That's why we're here. This is what our constituents elected us to do, was to come down here and vet issues. And so the agenda is full of bills that have not met deadline, that don't have Senate counterparts, that are not moving in the Senate. But we are here, and we're going to vet. I would hope that we would vet these bills adequately. But I do have a couple of questions, Mr. Chair. I have one for the bill's author. And, one of the reasons that we are all in the legislature this year, one of the biggest issues that we're here for is to lower health care costs and make sure that people have ample access to health care. And I'm just wondering, is this problem that you're trying to address so enormous that we need to take steps to actually limit health care access in rural areas?
Representative Mann.
Thank you, Mr. Chair, Representative. So the testifiers are conflating several issues, first of all. So let me clear those up, because that will bring a little clarity to this issue. So one thing that was said was that the number of employed physicians in large organizations is growing. But no physician is required to work for these organizations. And that particular part is not necessarily true, because if the number of employed physicians is growing, it's because physicians cannot practice by themselves anymore due to the current bureaucracy in this healthcare system. So they have to be employed physicians and not just working out on their own. And so when that happens and you start applying these non-compete clauses to physicians, you another thing I heard was that it can be used as a bargaining chip, which how many bad things do we put in a contract in order to be used as bargaining chips? And that argument is ridiculous in and of itself. In rural Minnesota, you could have asked me, Representative Barr, that question because I was a rural physician. I worked in a town of 1,000 people. Again, they're conflating a non-compete with essentially the rest of the contract. So in a rural area, a doctor may be offered a signing bonus, moving expenses. They can be bought special medical equipment, and that can happen anywhere. And those things come with a separate clause, if you will. If we give you X amount for a signing bonus, you have to work here for 3 years. Great, that's completely different. Then a non-compete is the issue what happens after those 3 years. So the investment that any organization makes onto that physician is paid back with time. And that this bill does nothing to touch that whatsoever. It's just that when that commitment time is done, then that physician is allowed to work anywhere they want. And we were given an example earlier about physicians in Duluth, how a group of physicians were very unhappy with where they were working. And in order for them to leave, they would have had to leave Duluth. So the town lost out on a group of physicians because of non-compete. So the non-compete is hurtful to rural communities. And I have seen that firsthand. I hope that answered your question.
Representative Scott.
Thank you, Mr. Chair. Well, sort of. How big of a problem is this across the state of Minnesota? I mean, this is the first we've heard of this issue. Physicians aren't beating down our doors to make this change. And to me, you know, we're entering into deciding what people can and cannot have in a contract. And I don't know, I went through real estate classes, and one of the things they always taught us about a contract is you can put anything in a contract if two parties agree to it.
Sure.
And so why would we want to take one of those tools in the toolbox for making a valid contract? And it's not like people are entering into this without knowing. I mean, we have well-educated people. We have physicians entering into contracts. They can say whether they agree or don't agree to a non-compete. And the people on the other side of that contract are well-educated as well. And if the physician was, you know, had any concerns, they can certainly hire their own attorney to work on their behalf. I just think that this bill is probably just, it's not needed, because you can agree to anything in a contract. You can say, I will not sign this document if it has a non-compete in it. We don't have to put it in statute the way that you're doing here. So I guess if you have feedback on those comments.
Mr. Mann.
Mr. Chair. Representative, so although physicians are generally very smart people, they are not lawyers. And so a lot of physicians don't actually understand what a non-compete is. I've had many physicians sign a contract not fully understanding what that means. And not only that, but again, this is an issue that it's not about contract law. I mean, I understand that's what it is, but it's about protecting physicians and patients. And that's really the bottom line of this, is we're trying to do everything we can in this healthcare system to make money and to make profit. That's what this is about, right? But at some point in time, we are going to step in, and this is what I'm doing today, and I'm going to say, no, today, it's not about money, it's not about profit, it's about protecting patients. And this is just a very, very small step in order to do that.
Mr. Chair, I would ask Mr. Cruz, I believe it is, to come up. I think he had some, maybe some input on some of my questioning.
Do you have a specific question for Mr. Cruz? Or Scott?
Well, I think if he could address the issue of contracts and the both sides of the contract and entering into that, and then also my line of questioning regarding rural care and access to rural care.
Thank you.
Mr. Cruz.
Thank you, Mr. Chair, members. With regard to both sides of the contract and how these actually work, you'll find there's a Massachusetts case. I'll give you the citation, 629 Northeast 2nd, 291, Falmouth OBGYN Associates Incorporated versus Richard C. Abisla. And it describes exactly the scenario that the author talked about in saying that, well, you can be made whole in these other ways. Non-compete is separate. It's over here just about geographic location. Now, if this were to pass into law, what the local courts are going to do is they're going to say, where else do we have this law? And they're going to find that this is a cut and paste of Massachusetts. And not many states have followed behind Massachusetts in this regard. And what they're going to find in that ruling is that even being made whole for the investments would be considered an inhibition under this language, which would mean that there would be no remedy, not just the location of practice, but not even a way to be made whole. And I want to comment on one other part of this. Centricare and Caris are not for profit. And so to the point that the testifier, the author makes about, this isn't about profits, oftentimes when these physician specialties leave, they become for-profit entities and compete against the non-for-profit, which has an obligation to serve the entire community's health needs. And they may not even accept Medicare, Medicaid patients. So I'm not saying that anybody has bad intentions. I'm saying I'm defending our intentions.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Herr.
Thank you, Mr. Chair, and thank you, Representative Mann, for bringing this forward. I don't know how many people in our committee manage a chronic condition, but I do. I have a kidney disease I've had since I was 16. I see multiple doctors all the time, and every time I have to leave, a physician leaves, I literally have to re-educate people on my condition because it's not very common. And I wish that there were abilities for me to be able to go with my physicians, but that's almost has never been the case. So I really appreciate you bringing this forward because it really is in the patient's best interest to be able to, if a doctor leaves and stays in the area, that they can still see that doctor. So I really appreciate that because I see 3 different doctors for my kidney disease. And because I've had really good care, and I've been really a good advocate for my own care. That's the only reason why I'm one of the 10% of people who have this condition that don't go into kidney failure, and that to expect patients to be able to manage their care the way I did is, I think it's an impossible task, and I had to be a stay-at-home mom to do that. And so I just wanted to thank you for bringing this forward. I just wanted to ask a couple of questions. I know that there's questions around the need for this type of bill, and Dr. Mann, Representative Mann, Dr. Mann, either one, can you just help me understand, because I have been following this quite a bit, in that there are less and less people choosing to go into the profession of being doctors because of the cost, and that's why universities are making med schools free to get people into those programs. So there really is already a shortage of doctors, and having prohibitive things in place would make it more difficult for people that want to be in this profession. Is that correct, Dr. Mann? Representative Mann?
Mr. Chair, Representative, yeah, so there's a lot of barriers not only to good patient care in our healthcare system, but also to quality providers. I mean, we're at a time right now where we are losing 1 physician a day to suicide. People graduate medical school with $200,000 to $300,000 in debt. And so, we could argue too that this is one of those bills that would also give physicians a little bit more freedom. But again, at the end of the day, we are not serving our patients well in many, many aspects. And this is just a very small piece of that.
Representative Herr.
And I did just a couple more comments here. So, and I did hear the idea about, how these systems are not for profit and they don't make a profit, but I did manage healthcare systems in my private sector life. And I met with many, many hospitals and healthcare systems that were nonprofits that made hundreds of millions into the billions of dollars in revenues that were in profits. And I don't know what they did with those profits, but just because you have a nonprofit status does not mean that you are not making profits. It does happen, and then they redirect those funds into other ways within their institutions. And so I don't want a not-for-profit status to confuse the situation here. And I had direct experience managing the finances of those organizations, so I do know. I did just want to add one more thing as well, is that I don't understand why there's opposition to this bill, because I worked in the financial services industry and we had non-competes, but the only reason those non-competes existed was because so we couldn't take our clients, or we couldn't take company like private data or information with us so that we could go and be profitable by ourselves. And I guess I don't understand why there is opposition, is because this has nothing, if hospitals are not making profits, they should have no investment in protecting why a physician can't leave and practice somewhere else. And so I'm a little bit confused by that. And so I did just want to make sure that I'm understanding that really at the end of the day, this is really about protecting patients, their ability to have access to physicians that they may have been working with, and to allow those physicians to be able to have other jobs within the communities that they've built by working at this one, maybe other particular job. Is that correct, Representative Mann?
Mr. Chair, so the issue, the reason why these things are in place is that so a physician doesn't leave that practice, go to work someplace else, and take their patients with them, because then that hospital will no longer get the money that comes from those patients, right? So the fact that we're arguing this bill is really highlights what's wrong with today's healthcare, is that we're arguing for the money. We're arguing for the profit. And no one, except for some people, are saying, let's argue for the patient, right? If we were arguing for the patient, we would not be having this conversation.
Thank you, Representative Mann.
Okay, let's see. I'm just taking the gavel for a second here. Representative Carlson.
Thank you, Madam Chair. Just a quick comment. Representative Mann, yes, I completely agree with you. The idea of putting the patient first for allowing for the continuity of care is important. I support your bill.
Representative Lucero.
Thank you, Madam Chair. A couple questions here. The first one is, did I understand the bill author correctly? Did you say that there is current bureaucratic red tape that exists that prevents physicians from going into business for themselves?
Representative Mann.
Madam Chair, yes.
Well,
Representative Lucero.
Madam Chair, then I would suggest that perhaps there would be consideration given to removing some of the bureaucratic red tape and regulatory mandates that are preventing physicians from engaging in their practice. The next question I would have for the bill author is, are you aware of any physicians that have involuntarily entered into these non-compete contracts?
Representative Mann.
Mr. Chair. Well, to your previous point, it's not only just bureaucratic red tape that we can get rid of, it's the way the healthcare system works in general, right? A physician can't go into private practice if they have to hire a staff of 25 people to get through all the paperwork that's required in order to meet certain standards in today's healthcare system, most of which are complete waste of time, honestly. So that's part of the issue, is if I could change the entire healthcare system, I absolutely would, and I'm working on that, so thanks for bringing that up. The second part is I know physicians who have entered into these contracts not necessarily knowing the consequences of a non-compete, and because of that, they really had to alter their lives when that kind of came to light, unfortunately.
Representative Lucero.
Thank you, Mr. Chair. So physicians, highly educated, are entering into contracts unaware of what they're doing, or perhaps they have a change of attitude after they've made a commitment, is not a reason to null and void the voluntary action that they took. The next question I would have is, does the bill author, do you at least at all slightly agree that if a hospital or whatever organization, in order to incentivize some of these highly specialized professionals to move out to their areas, they're paying their moving expenses, they're paying for training, they might pay for continuing education, sign-on bonuses, et cetera, that if you're, in order for them to recoup the upfront investment that they have in these professionals to incentivize them to come out in the first place, if you eliminate their ability to recoup their costs, do you not at all acknowledge that this might disincentivize physicians from coming out, and therefore you're going to worsen the problem you're attempting to fix?
Representative Lucero, incentivize is not a real word, but go ahead, Representative Mann.
Mr. Chair.
I'm sorry, that's editorial comment.
So first of all, Representative Lucero, I never said that that's the reason that physicians don't know what they're doing is the reason for this bill. So that was a false assumption on your part. Second of all, again, like I explained previously, this bill has nothing to do with those incentives. It has nothing to do with recruitment, bonuses, medical equipment, getting people out to rural areas. It has nothing to do with that, because the hospitals can do all of those things and require a physician to stay there for 3, 5, 10, whatever years. The last contract I almost signed had required me to stay in place for 7 years, which is fine. This has nothing to do with any of that. This simply says that when that time is up, that physician can go practice wherever they like, after they've spent the time there that was required of them and the hospital has recouped their cost.
Thanks, Representative Lucero. Last question.
Last question. Thank you, Mr. Chair. Well, that's not true. This absolutely does have an impact on that. The medical professional field is not the only field that has this activity. I'm in the IT field, another highly specialized field. And there are non-compete clauses because it's well understood that we, as highly skilled professionals in demand, there's other employers that are competing for our skill set. And an employer has a vested interest in having a competing employer make the investment to train somebody to increase their skill level and knowledge, and let one employer take that cost, and then have another employer to simply siphon them off and not have to take any of that cost. And that is exactly what's going to happen here. So absolutely it does have a reality in preventing professionals after they've completed the initial contract from becoming a direct competitor to the first employer. So, Mr. Chair, I would highly encourage a no vote.
Representative Hassan.
Thank you, Mr. Chair. Thank you, Representative Mann, for this bill. I think that we're driving away the conversation, the most important piece of this legislation, which is the patient care and the disruption of care. When a doctor leaves, the patients are the ones that lose. The hospital doesn't lose because they'll find another doctor. The doctor will find somewhere else to practice, and I think the biggest losers in this conversation are the patients. And the reason why we got elected is to advocate for people, and that's what we're doing. So thank you for the bill, and I support this bill.
Representative Johnson.
Chair Lesh, Representative Mann. First of all, I'm going to take exception to a statement you made. Duluth, a Class A city, is not rural Minnesota. Where I come from, Cambridge, population under 10,000. The county's population is under 40,000. That is rural Minnesota. A Class A city is not rural. That's a metropolitan area. You have more than one hospital in Duluth. In my county, I have one. It's 20 to 30 miles between hospitals. Once you get north of Cambridge, there's only two hospitals between Cambridge and Duluth. And that brings up the other issue that's not being talked about: access to health care. Minnesota's probably one of the best health care systems in the country. The vast majority of our hospitals out there are not for profit. They're not out there to make a profit. They're not for profit. They're to give the best health care they can for the dollars that they have. In greater Minnesota, most of our patients are on medical assistance of some type. The hospitals there generally lose money. These non-compete clauses are there for a reason. That's to keep the doctors there as long as possible, as far as their contracts, so they don't leave their contracts early for the investment these hospitals that are actually losing money put in to keep those, to provide the service for the patients in their community, to give the patients and the people in their community the best care possible without having to drive to a metropolitan area of the Minneapolis, Duluth, at a high expense. And a lot of times it's the elderly that cannot afford or cannot get to those hospitals with those specialty cares. And another issue that's going to probably come up with this bill, because we're going to have doctor hopping. They don't have to stay. There's no non-compete. Just in these cities with more than one hospital, these doctors are going to be jumping from hospital to hospital to hospital where they can get the best bang for their buck, which is good. They're there to put money in their pocket, which I don't blame them. They all want to survive and do the best they can, but that raises healthcare costs. Our healthcare costs have gone through the roof to the point where healthcare is no longer accessible to the vast majority of the people. They're required to have insurance, but their deductibles are so high they can't afford to go to the doctor. And I believe this is just going to make it worse.
Representative Cantrell.
Thank you, Mr. Chair, and thank you, Representative Dr. Mann, for bringing this bill forward. I just had a quick question for you. So are there situations in which, let's say, a doctor is seeking employment at a hospital, and let's say the hospital says, well, okay, here, let's sign this contract. It has this non-compete clause in it. And the doctor says, no, I'm not going to sign that. And they say, we have 40 other people lined up who will. Is that a situation that happens? So it's kind of forcing the doctors into this difficult situation?
Representative Mann.
Mr. Chair, Representative Cantrell, yeah, especially in metro areas, that happens all the time, right? You can be essentially forced to sign a contract that you don't agree with, which includes a non-compete, which then if you serve your time, their hospital recoups their cost, and you want to switch because maybe you don't even like your boss. Maybe you don't get along with other physicians. Maybe you're really unhappy where you're working. You have to relocate your entire family to continue working and to pay your bills and to pay your student loans, right? So yeah, that definitely happens, especially in the metro area.
Representative Cantrell.
Thank you, Mr. Chair, and thank you, Representative Mann. So what this bill seeks to do is prevent doctors from being forced into a situation where they might only have the option of signing a contract with one of these clauses in it that not only may and often does substantially deteriorate their ability to have their own personal stability, but also be able to provide the best quality of care for their patients. But I also think, too, that it's important for us as a committee and as a body to not think of clients and patients as being in the same group. I mean, clients in any other type of industry are absolutely different from patients like Representative Herb, like myself, who we're both folks living with chronic conditions. We need that continuity of care. And so if anything, this bill is preserving the continuity of care, and it's also making sure that we balance the scales for physicians as well. So I support this bill, Representative Mann, and I thank you so much for bringing it forward.
Representative Robbins.
Thank you, Mr. Chair. Thank you, Representative Mann. So I just had a couple questions. First, regarding the patient, keeping your patients and the continuity of care issue, I just wanted to ask, when a doctor leaves a certain clinic or provider, taking the patient might not necessarily be able to follow them because the doctor might not take the insurance the patient had that was taken by the previous provider. So I'm not sure it's really a clear, direct link like we're discussing it. The doctor may not take the patient's insurance and may not be able to take that patient again. Is that correct?
Representative Mann.
Mr. Chair, yeah, so it depends where that physician goes to work. The insurance coverage certainly might change. And I think you bring up a really good point, and the other representative also brought up several really great points, is that our system doesn't work for patients. Our system is not patient-driven. Our system is not outcome-driven. Our system is profit-driven. And because of that, that is one of the issues that occurs.
Thank you, Representative Mann. And I agree with your larger point. Even though I'm not supporting this bill, I think the implications for contract law are serious, and I think the larger fix is more what we need than this particular legislation. But I do want to make it clear that just because the doctor leaves, the patient doesn't necessarily get to keep the continuity of care. And secondly, to the discussion with Representative Cantrell when you're talking about relocating, I do understand that's a problem, but especially if it's in the metro area. I mean, if it's a 25-mile non-compete, you could keep your family in your home and your kids in your school district and just drive 25 miles. I mean, in the metro, that's a very common level of commute, so I don't see why that's such a big harm.
Representative Mann.
Mr. Chair, so 25 miles is just a random number we picked out of the air today. It can be significantly longer. And especially in rural areas or, I mean, honestly, even in the winter where the roads are bad and we're in a rural area, that kind of commute is actually a really big deal. And some physicians pick a location because they don't want to commute. Some physicians have, certain quality of life issues that they take into consideration when they choose a job. And to restrict someone and tell them where they can and can't work, I mean, it goes through, it goes against all the principles that we supposedly stand for in this committee: free market, capitalism, all of that. It goes directly against all those things.
Representative Zhang.
Mr. Chair, I'll keep this short. From hearing from the testimonies today, I think I know who has my best interests. And if I'm sick, I'm going to see a doctor, not a lawyer. And I'm just very glad that you're bringing this bill forward and that you're my unofficial in-house physician. And I fully support this bill because we have to do more. The focus of conversation should be on patients and not big corporations or businesses trying to make money out of patients who are more concerned about pocketing themselves and of all patients. So thank you for this.
Representative Considine.
Thank you, Mr. Chair. And as I'm listening to the testimony, I think this bill really gets down to the free market, and that this helps strengthen the free market and competition in the medical field. So I want to thank you, Representative Lucero, for helping make up my mind. Thank you.
Last one on the list is Representative Herb. You already spoke, but one question.
No, that's okay.
No, okay.
Mr. Chair, one last
Chair
question.
Scott?
Thank you. I just want to set the record straight here. I don't think either side of the aisle is saying that this is not about the patients. That's what we've been arguing. For you to say that this bill is solely focused on patients, I think is mischaracterizing what this bill is really doing. We have heard numerous testimony from people that understand this issue that this will hurt access for patients in rural Minnesota in particular. This is, and you talk about the free markets, Representative Considine, the free markets are based in part on contracts. And what the representative, the bill's author today is doing is try to intervene in these contracts and say what can and cannot be agreed to. So I think that this has been mischaracterized by the other side. And Representative Mann, you said that in the beginning of your testimony that there's a shortage of physicians, that we're losing them daily. But at the same time, you agreed with Representative Cantrell's characterization that, there's a long line of physicians waiting to sign up to go to work, and that those two statements are incongruent. I think we've got a problem here that that is really not a problem. I think it's something that a physician can easily work their way through a contract. If they don't understand the contract, they can hire their own attorney. But I think this has been largely mischaracterized, and I would ask for a roll call on this vote, Mr. Chair.
Roll call's been requested. Before we move to closing comments, we're not doing the ping pong. I know they do that in tax committee when someone gets brought up, but this will go on for another half hour. It was scheduled to go for 20 minutes, and now we're at 45. So we're not going to do any more on that. Representative Lucero wants to talk to. Everyone wants to talk. Before we go to closing comments, or from the author, Representative Mann, I would just note that I was looking forward to I think a little bit something different in this debate. I was looking forward to the opposition bringing forward what would be a reasonable restriction or a reasonable non-compete agreement. And instead, they just came up and said, nope, there's no such thing as a good one. And I was kind of looking, I suspect there probably, is room for one, but they didn't propose any alternative. We place limits on contracts all the time. It's illegal. You can't do an illegal contract. You can't do a contract that abridges somebody's human rights or civil rights. And in fact, this body routinely restricts certain industries from doing contracts because they hurt a different industry. So there's a East African, I think it's a Kenyan proverb for that. It says, when elephants fight, it's the grass that suffers. And yes, there are two groups here fighting over what should be contract. But I guess in the future, I would hope that if someone says, no, this isn't good, here's the idea we should do, and that didn't happen. But Representative Mann, closing comments before we go to the roll call.
Thank you, Mr. Chair. So I just want to say that I don't think that this bill has been mischaracterized whatsoever. It's pretty cut and dry. It is about patient care. It's about continuity of care, which we know decreases healthcare costs, which we know has better healthcare outcomes for people. And that's what it's about. And I said that we're losing physicians to suicide, one a day on average. That doesn't mean that we don't have areas that we have lots of physicians who want to work at and areas where we don't have enough physicians that want to work there. So in closing, really this bill is about, again, patient care. I'm here standing up for patients, and I request your support.
Thank you. The motion was made by Representative, maybe the chair or something. I think I made it, that it be recommended to be referred to the General Register. A roll call has been requested. Chair votes aye.
Representative Mueller?
Yes.
Representative Scott?
No.
Representative Barr?
No.
Representative Cantrell?
Yes.
Representative Carlson?
Yes.
Representative Considine?
Free markets, yes.
Representative Grossel? Representative Hassan?
Yes.
Representative Herr?
Yes.
Representative Johnson?
No.
Representative Lucero?
No.
Representative Mariani?
Yes.
Representative Noor?
Yes.
Representative Robbins? No. Representative Zhang?
Hell yeah.
On a vote of 10 to 5, the motion does prevail. Thank you, Representative
Thank you,
Mann.
members and Mr. Chair.
Representative Lee has been patiently waiting. Please come on up, Representative Lee. Do we have a motion for Representative Lee's bill, House File 2000, to be referred to? Oh, it's going to be laid over for possible inclusion in the Finance Omnibus Bill. Okay, so that's the motion. Go ahead to your bill, Representative Lee.
Thank you, Mr. Chair and members, for the opportunity to present House File 2000. Currently, when a state agency seeks bids from contractor for goods and services of at least $100,000, the agency cannot accept bids from contractors unless those contractors have a diversity hiring plan that has been approved by the Minnesota Department of Human Rights. This requirement applies only to contractors that have more than 40 full-time employees. This law has been on the books for a long time, and around 2,100 contractors in the state currently have certificates of compliance from the Department of Human Rights that are good for 4 years. House File 2000 add equity goals to bonding projects and extend these requirements in law to cities, counties, and other entities that receive proceeds from the general obligation bonds. And I would like to turn it over to my testifier.
Good, Mr. Butel, welcome back to committee.
Thank you, Chair Lesh and members of the committee. For the record, my name is Scott Butel. I am the Assistant Commissioner with the Minnesota Department of Human Rights. We appreciate the committee taking time today to hear this Department of Human Rights agency bill, which clarifies and extends what state general obligation bonding projects are covered by the state's Workforce Certificate of Compliance and Equal Pay Certificate of Compliance programs. Currently, these programs cover bonding projects overseen by entities such as the Metropolitan Council or the Department of Administration, which are generally covered by these programs. Bonding projects funded by the state but contracted for by currently non-covered entities, such as most cities or counties, are not covered by these programs right now. This proposal would require that all projects that meet the funding thresholds, regardless of which entity is running them, and require contractors to comply with these equity requirements. This will help to ensure that workforce inclusion opportunities exist on all programs and that all of the state's business partners are following existing equal pay laws. Contractors would get a certificate of compliance on the front end, which the department generally processes in about 3 days for applications. The primary obligation for compliance is on the contractor. As Representative Lee, there's about 2,100 certified contractors in the state under the workforce program and about 1,700 under the equal pay program because the threshold is $500,000, so it's a little higher. The local unit of government or other entity running a bonding project, so receiving money from the state, their duty merely would be to inform bidders of these requirements and verify with the standard form that they had obtained appropriate certificates from the Department of Human Rights. Contractors would need to make good faith efforts to hire women and people of color on these projects with goals set by regions around the state. In the handout that you received, there's a map of those goals, and they're different based on the area of the state. For the equal pay certificate, contractors must certify that they're in compliance with equal pay certificate laws. This was a program created by the legislature in 2014. The Department of Human Rights also has existing authority to audit contractors under these programs, which we generally do on a random basis once those contractors are underway. This bill really recognizes the successes that we've seen on some large state-funded projects like the restoration of our own Capitol building and the U.S. Bank Stadium in recruiting and hiring workforces that are more reflective of Minnesota's population. On both of these projects, contractors exceeded hiring goals for both women and people of color, helping to diversify their workforces and provide opportunities for more folks within Minnesota. In a labor market with stiff competition for employees and changing demographics, diversifying hiring efforts has had a positive impact for companies and communities, and the Department of Human Rights really works as a proactive partner with our contractors to help them build the systems and practices they need to recruit and retain these folks. So we appreciate the committee hopefully moving this forward to include it in the Omnibus Bill to help ensure that women, people of color, and individuals with disabilities have an opportunity to benefit from hiring on these state-funded projects.
Thank you.
Thank you so much.
For Mr. Butel. Chair Johnson.
Chair Lesh, members. I have concerns on this. I understand the reason for it, but I've been at some of my city council, county board meetings, township meetings. They're doing bids for projects right now, and they've done over the past year. They're setting up these bids 2, 3, 4 times already because they're not getting any bids. And this, I like the idea of this, but this is just going to limit the number of people that can actually bid on these projects, and they can't find people to bid on them now. So this might actually hurt greater Minnesota.
Chair Scott.
Thank you, Mr. Chair. And this might be for the bill author. I guess it probably is. It looks like House File 2000 and 2001 are amending the same area of statute. And I'm just wondering to the bill author why it wasn't just combined into one bill.
Representative Lee.
Mr. Chair and Representative Scott would defer to Mr. Butel. These are 2 agency bills from the Department of Human Rights.
Mr. Butel. Well,
Oh, did you call him Mr. Butel?
yeah.
Okay.
You want to answer that, Mr. Butel?
Yes, please. Thank you, Mr. Chair. Representative Scott, these two bills sort of started out life with kind of 2 separate genesises. So this bill was about, this substantively expands the number of projects that are being covered under this statute. House File 2001, being carried by Representative Cantrell, is a technical bill to try to combine 2 paragraphs together to provide clarification. We had some questions from another state agency who had a little bit of confusion and concern about how these 2 paragraphs were being interpreted for in-state and out-of-state contractors. And so the request that was made from, as we were working forward was to keep these 2 separate, as one is sort of a purely technical bill with House File 2001, and this one is a little bit more substantive. And then just for context, we've definitely spoken with council about how, as this goes into an omnibus, how these 2 would be merged into one. And I think the idea would be to take House File 2001 sort of as the base and then add in the provisions referencing the GEO-bond statute.
Chair Scott.
Mr. Chair, thank you. Mr. Butel, my understanding is that you agreed in the Labor Committee to merge the 2 bills. Did I get wrong information on that?
Mr. Butel.
Chair Lesh, I'm sorry, and Representative Scott. In the conversation in Labor, I believe what we committed to was making sure as this moved forward that there would be an opportunity to merge those if that came up, and I think we see that as this goes into the omnibus.
Mr. Chair, thank you. I don't see a good reason since it's the very same exact section of statute, why this is 2 bills versus 1. It's going to end up being 1 anyway. So that's all,
Okay.
Mr. Chair.
Thank you. There being no other committee discussion, Chair lays over House File 2000 for possible inclusion in the Omnibus Finance Bill.
Thank you, Mr. Chair.
Thank you, Representative Lee and Mr. Butel. Is Representative Dehn here? Okay. Well, we have the Secretary of State patiently waiting for you to get here. So, okay, this bill, House File 1603, the motion on it is that it be recommended to be re-referred to the Ways and Means Committee. Do we have a motion on that? Representative Cantrell makes that motion. And members, the scope of our discussion involves the data practices provisions, lines 2.6 to 2.9, 8.6 to 8.7, 42.31 to 43.40, I'm imagining, and what? And 76.28 to 76.29. And the penalty provisions, which are lines 56.20 to 56.16 and 67.17 to 68.20. Okay, welcome to the committee, Representative Dehn.
Thank you, Mr. Chair. And I know that there are a few provisions in here that Secretary Simon will want to speak to. I believe we're here because of some concerns around some of the data and what's going to happen with it. And my understanding when the bill was shaped, that we're not doing a whole lot to change any data classifications or anything like that. So I would just, open it up to questions that individuals might have, unless you want me to go through each of the sections.
No, I don't.
Okay.
Are there questions that folks have? Did you want to do a little spiel, Mr. Secretary?
Mr. Chair.
Okay, welcome back to your old committee.
Thank you, Mr. Chair. This is the first time I've been before this committee this session, so thank you, members, for your time. I know you have a full plate. I'll try to color inside the lines, so to speak, and just talk about what's within the committee's jurisdiction. In particular, I want to talk about the item starting on line 42.31. That has to do with the presidential nominating primary. I'm really here to sound the alarm, as I have in both chambers and in multiple committees. This is really a necessary provision in my judgment, and I think in the judgment of most Minnesotans. So in 2016, as many of you recall, we had huge turnout at the precinct caucuses. We had an open seat presidential election year, a lot of energy and excitement in both political parties that literally overwhelmed the ability of volunteers in, church basements and junior high classrooms and all the rest to handle. So the legislature in 2016 decided that only for the office of president, and only obviously once every 4 years, we would become a hybrid state. We're keeping caucuses for everything else. I know there are many people in this room who are the product of the caucus process. That's not changing. So whether it's state legislator or secretary of state or governor, everything's staying the same, platform issues. But for this one office, the legislature decided in 2016 to pull it out and do a real election, a real presidential primary. That will be next March 3rd, Super Tuesday, along with many other states. So Minnesota will share that spotlight. There was a feeling not only that the crowds were unmanageable in some cases, but also that the caucus system for such a high-interest election tended to shut out people in the sense that there was no absentee option. So if you're a parent with child care issues, or you're working a late shift at work, or you're in the military, or you're studying abroad, or whatever, there is no meaningful absentee provision for you to have a voice in your party's presidential nominee. So the problem with what happened in 2016, Mr. Chair and members, is that the way the bill was drafted, there will be separate ballots for each political party. That's unlike our typical experience in Minnesota for the August primary, for example. Separate ballots, okay, so far so good. But the problem is that the record of which ballot a voter chooses will be public. That will be a public record. So if you go into a polling place or you vote absentee and you say, give me the DFL ballot for president or the Republican ballot for president or either of the two new major parties that we have now, both of which support marijuana legalization, for any of those four major parties, the choice of ballot is now public. Obviously not the choice of candidate. We still have a secret ballot. But your choice of party will be, and that is a backdoor party registration system, something we have never had since statehood in Minnesota. And I would say it's even worse than a state registration system because, as many of you know from experience, if you've lived in another state that has party registration or you know someone who has, in every other state in America that has party registration, there's always an option to register as independent or unaffiliated. That is not an option this coming March 3rd. So unless the legislature makes a change this year, it means everyone who wants to have a voice in choosing a presidential nominee has to pick a team, and the record of which team they picked will follow them for years. That means your neighbor, that means your employer, that means anyone in your life that is publicly accessible information. We've never gone in for that in Minnesota. And think about some of the occupations or professions that just as a matter of course might opt out from voting. If you're a member of the clergy, if you're a journalist, if you're a school administrator, if you're a judge, there are many more I'm sure that you could think of, you might just not bother at all voting because it's not in your interest to wear your party identification on your sleeve. So this is a problem. I think all of our constituents will be quite upset to learn, if no change is made, that they're going to have to sign up with a team, and that will be a publicly available record. So the main thing that this provision does is closes that loophole and makes sure that people can vote freely in that presidential primary without fear that their employer, their neighbor, and others will have access to their party affiliation. So that's the main takeaway, I think, from this provision. I'm happy to stand for questions, comments,
Thank you for
pushback.
highlighting that, Secretary Simon. I mean, that it is kind of something that I think is probably of high importance to this committee. Representative Cantrell.
Thank you, Mr. Chair, and thank you, Secretary Simon. I just want to say that I absolutely agree with you that this needs to be changed for all the reasons that you enumerated. We as Minnesotans pride ourselves on independence and being able to really make sure that we choose the best candidate possible. And somebody shouldn't have this data being public and having that decision whether or not they vote on the Democrat ticket or the Republican ticket hanging over their head. So I really appreciate you coming forward, and I support this bill. Thank you.
Thank you. Any other questions? Chair Scott.
Thank you, Mr. Chair. And I'm just wondering if the bill's author could explain Article 5 on 46.7 through 46.17.
Representative is that part of their scope of our bill?
Not
what we're
necessarily,
looking
but
at?
with the whole bill is before us, so.
It is, but I mean, this is going through, like, we posted it like this, Chair Scott. I mean, just if you can answer it briefly, Representative Dehn. I don't want to go far afield on this, but I'll obtain Chair Scott.
Mr. Chair, I know that this is regarding the presidential elector, and I know that Mr. Secretary could answer that much quicker than I could, because I'm going to dance around a little
Go
bit
ahead,
till I
Mr.
get to the
Secretary.
point.
Thank you, Mr.
No,
Chair.
does people call you that, don't they, Mr. Secretary?
Sometimes.
They don't really?
I call him Mr. Secretary.
I think it's kind of cool. Go ahead.
Thank you, Mr. Chair. And Representative Scott, yeah, this is the section that you pointed out is part of the national popular vote provision, and this particular one that you have isolated here talks about how this interstate compact will only take effect basically when 270 electoral votes worth of states also joins the compact. So, you know, whether you're for it or against it, if Minnesota decides to do this, it will only kick in if other states adding to 270 have also done the same thing. That's what this provision says.
Okay, thank you.
Thank you.
Is that good enough, Chair Scott?
I have some other questions, Mr. Chair, regarding the data.
Okay, go ahead.
And different things. So if automatic voter registration that we heard in the Winkler bill, if it only applies to those eligible to vote, how will the driver's license applications under Representative Winkler's bill for driver's licenses for undocumented immigrants be handled? How will that be handled?
Mr. Secretary.
Do you want to take it?
Yeah.
Wait a second.
Mr. Chair?
Go ahead, Representative Dehn.
Well, with the designation of not for voting, it will clearly state on the driver's license and as part of the process that the individual receiving that license is not eligible to vote. So that data won't be held in the same way that it will be for an individual who is eligible to vote in Minnesota.
So, Mr. Chair, thank you.
Sure, Scott.
So will there be a separate database with just those people's information?
Representative Dehn.
Mr. Chair, I believe there will have to be some data set. The access to the data set, I believe, will be very, very different than a traditional data set, but I'll let Secretary Simon speak to that specifically.
Go ahead,
Mr. Chair.
Secretary Simon.
Thank you, Mr. Chair and Representative Scott. Yes, it will be, there will be two ways that the language that Representative Dehn talked about will be used. One will be it will physically appear on the license. But licenses smudge, licenses, you know, can have wear and tear, but it's also will be noted in the system, and that will be separable from all the rest of the data as well. And I might add that this is actually a stronger provision than has existed traditionally in Minnesota. I use an example from my own family. My mother was never a U.S. citizen. She lived here for decades and was a green card holder, but she had a Minnesota driver's license. And there was never, I remember talking with her about this, there was never anything on her driver's license that said, or as far as I know back then, she's been gone a while now, but that was electronic, that sort of sorted out her record, but now we're going to have that both electronically and physically on the driver's license. So I would say it's stronger than it has been traditionally in Minnesota.
Mr. Chair, so I'm trying to understand, so, and I know that it's not your bill, the driver's license information, well, the Winkler's bill is a separate bill, but so when a person comes in to apply for a driver's license, will the applications be any different for people that are seeking the non-compliant driver's licenses than not? Because what I'm concerned about is there's going to be a box there to check, you know, whether you're eligible to vote or not. And it's a felony if you check that box and you don't know what the heck you're doing, right? So will there be a separate application for people that want a non-compliant driver's license?
Just, can I clarify? Chair Scott, are you asking about the language in this bill?
Yeah, he has the motor voter piece in this bill. It has to do with the data that's there. So,
Mr. Chair, just
Representative Dehn.
to be clear, the non-compliant driver's license registration will be different than the compliant registration, and the compliant registration is what the motor voter, as it's called, registration will be accompanied with. It won't be accompanied with the other application.
Chair Scott.
Okay. All right. I'm a little bit confused, but the other issue that I'm concerned about is implementing something like this with people's, driver's license data, and will the MNLAR system even be able to handle this and the differentiations between all the different driver's licenses that we're now going to be implementing between Real ID, compliant, non-compliant, these compliant, non-compliant, and I'm assuming there would have to be driver's permits that are going to be the same way. And I'm just wondering if MNLARS is going to be able to handle that and how soon that might happen, because we may be passing a law here that may not be able to be implemented for several years yet to come until MNLARS is fixed.
Well, I'm not gonna have the Secretary of State, Representative Dehn, answer MNLAR's questions. I mean, that's a whole nother burrito.
But
That's kind of
Mr. Chair, this bill is before us now, and it has direct implications to what's going on
data
with.
provisions of this bill before this committee are related to what we're doing. So, I mean, answer with respect to the parameters that I talked about, if you can, Representative Dehn.
Yeah,
because
Mr. Chair and members and Representative Scott, actually, the MNLAR system will not be the system that's used relative to this. It'll be part of the FAST system. And I believe there's someone from DPS.
We're not bringing in
Okay,
DPS.
okay. Well, I just wanted to put it out there, Mr. Chair.
Okay. Representative Scott.
Well, I thank you for that. Thank you for letting me know that it'll be a different system altogether. Some reassurances there that we won't have the failed MNLAR system that we have to deal with in regard to that. So that's my line of questioning for the moment.
Thank you. Chair Johnson.
Chair Lesh, this question is a little bit for Secretary Simon. In the DL issue, which does have the data, in California they found over 300,000 undocumented individuals that were put into the voter registration. In the House File 1500, it calls for, if that information is inadvertently shared or is shared with anybody else, it's a $10,000 fine per incident, or up to a $10,000 fine. And I'm just wondering if this Secretary Simons has the funds available if even 100,000 names got inadvertently on the voter registration poll books and sent out. That data would be a multi-million-dollar fine. I'm just wondering if the Secretary of State's office is ready to pay that fine if that should happen.
Secretary Simon.
Mr. Chair, so Representative Johnson, as I understand the California issue, the fine, unless I'm misunderstanding, the fine is on the individual, not the government entity necessarily. But even if we're on the government entity, the way that it works in Minnesota is that we provide the overall structure, the statewide voter registration system, but our registration system is largely county-based. So they make use of the system. They input the voter registration into the system. But if that were to happen, it would probably be an error that lies elsewhere other than the Secretary of State's office. That's just the way that the system works. So I can't speak for any particular county on that. And I don't know what penalty provision you're specifically talking about in this bill. But my understanding of the California bill is that it's something different, or the California law, I should say.
Thank you. Chair Johnson.
Chair Lesh, Secretary Simon, that's the issue in the House File 1500. It's up to a $10,000 fine for disseminating that information. And so is it going to be the Secretary of State's office disseminating to the counties? Is it going to be the counties put it in the poll books? Is it going to be the election judge who's going to be paying that $10,000 fine for every name that's there was disseminated? As far as was your mother that had the green card and got the driver's license in Minnesota now? If you're here legally with your green card, you can get a Minnesota driver's license. That is the law now. With the motor voter issue, we're going to have to figure that out, how that's going to work. Because that's a lot of details that's not in the bill dealing with the driver's license that the Transportation Committee has to figure out. And I'm not sure if this bill has been there yet or not, or if the motor voter bill been to transportation. But there's a lot of issues with that, dealing with those who can legally get driver's license now that can have to be dealt with, should motor voter registration actually go into effect.
Representative Hassan.
Just a quick question, Mr. Chair. Is House File 1500 part of this?
No, it's not. It's not
Okay.
before the committee.
All right, for a minute, I was confused. I thought I was looking for House File 1500 in here.
Go ahead.
And then just for the record, I want to comment on this issue about voting in an election when you're not undocumented. People, immigrants and refugees and people who are undocumented are afraid of the government. It's not easy for them to run into, election polls and vote illegally. I know my own community, I have done, community organizing. It's really hard for the ones that are citizens even to want to vote. Like, they don't want to do that. So just for the record, people who are undocumented and immigrants and refugees in this country do not want to commit crimes by illegally voting. That's it.
Representative Robbins.
Thank you, Mr. Chair. I just had a quick question for House Research. So what is the current data classification for voter registration information?
Mr. Hopkins.
Mr. Chair, members of the committee, so lists of registered voters are publicly available under current law.
And so,
Robbins.
thank you, Mr. Chair, sorry. So would applicant data for those not eligible to vote also be public?
Mr. Hopkins.
Mr. Chair, members of the committee, I'm not sure about people that apply and are not eligible to vote. I'm not sure if there's a classification in law that exists for that data currently. Maybe the testifiers would know. I'm not sure.
Thank you.
Okay, what was the motion on this? Okay, the Representative Cantrell's motion is that House File 1603 be recommended to be re-referred to Ways and Means. All in favor say aye. Aye. All opposed say no. No. Motion passes. Thank you.
Thank you, members.
Representative Dehn, you have 2367. Is that more simple than this last one?
Mr. Chair, I hope it's more simple. I do have a testifier who can speak to possibly some specific questions. She might also want to speak for a couple of minutes about how important this is for the safety in our community. So if Attorney Susanna DeLeon could come forward, if you could recognize her for a couple of minutes. She's been hanging out for a long time.
Okay, the motion on this is that it be re-referred to Ways and Means. Representative Cantrell makes that motion, and you've got an amendment. Is that right, Representative Dehn?
Yes, Mr. Chair, it's a small amendment that makes some slight changes to add some clarification.
Which amendment is this? The A2 amendment. Representative Dorn moves the A2 amendment to get the bill in the shape the author desires. All in favor say aye. Aye. All opposed say no. Motion passes. To your bill as amended, Representative Dehn.
So the House File 2367 is regarding the U visa, and currently in our state, well, for those of you who don't know, the U visa is a process by which an individual who is here undocumented that is a victim of a crime actually has an opportunity to, one, report that crime without reprisal, and at the same time, it also then creates an opportunity for those individuals to remain in this country as long as they are cooperating and working with law enforcement related to the crime. And this is a bill that's been around for quite some time, and there's no uniformity in the state And what this is doing is trying to create some uniformity so that it doesn't matter if your offense happened in Golden Valley versus Minneapolis. You'll be treated the same way, as well as how it gets processed and the number of days and those other types of things. So really what this is taking what's already happening in several cities in the state of Minnesota and making it uniform across the state.
Excellent. Thank you. Oh, okay. Go ahead. Introduce yourself for the record.
Thank you, Mr. Chair. My name is Susana de Leon. I am an attorney.
I'm sorry, say your name again.
Susana, S-U-S-A-N-A, de Leon, D-E-L-E-O-N. I am an attorney representing victims of crime for about 20 years now. And I have worked with the city of Minneapolis in developing their own U-Visa regulations and the U-Visa bill that passed the city of Minneapolis in 2017. It is very important for victims of crime to have an assurance that they can reach out to law enforcement and that they will not be targeted because of their immigration background. It creates extreme confidence in the immigrant community to collaborate, to cooperate with law enforcement, and it results in safer communities. For the years that I have worked with victims, we have requested from many places in the state this certification. Some places are not familiar with it, others are, and for the most part, we are able to get the certifications done. Now, for the city of St. Paul and Minneapolis, there is an ordinance that covers them, as well as, I think, Northfield. And this bill would certainly make it uniform across the state. The other thing you have to consider is that the certification in no way is an acknowledgement of law enforcement that immigration has to approve the visa. The certification is just an acknowledgement that this person was the victim of a crime, is cooperating or has cooperated with law enforcement, and or will likely cooperate with law enforcement in the future. So in no way signing a certificate is a determination by law enforcement that the U-Visa process should be approved. It is all up to the Immigration and Citizenship Service to approve the U-Visa. So what you would be doing by approving this bill is making a process that can be used in many areas where law enforcement might not be so familiar with a U-Visa.
Thank you. Questions for Ms. De Leon? Chair Scott.
Thank you, Mr. Chair. I just had a couple of questions, and this is it's a new concept to me. Maybe others have heard about this, but are there been a lot of people in the state of Minnesota that have requested a U-Visa? And is there anything, since it's a federal law now, is there anything preventing people from inquiring about getting one right now?
I can understand the second part of your question.
Chair Scott.
So, Mr. Chair, thank you. So, to the testifier, the U-Visa is a federal law, right? It's set up in federal law where people can get one of these visas.
That is correct.
Is there a specific reason that Minnesota has to have a law on top of that? What's different between what we're trying to do here and what the federal law does? And then how many people have, if you know the answer, how many people have inquired about obtaining a U-Visa in the state of Minnesota?
Thank you. I understand both questions. The first is just alone in the city of Minneapolis in 2018, there were 750 requests. And statewide, I wouldn't be able to tell you. Federal law created the U-Visa to help victims of crime, but for them to open that door, they must first have a signature from a certifying official that says, yes, this person was the victim of crime or criminal activity. And that's all that the state is doing, fulfilling the requirement of a federal law.
Okay. Thank you, Mr. Chair. And so there have been 700 requests for this in Minneapolis in the last year?
In the last year, there were 750.
Wow, that's a lot of victims of crime. Thank you, Mr. Chair. Would you be able to define what a family member is in this bill? Who does that include? Is that just immediate family, or does it go beyond that?
Ms. De Leon.
The victim is the person who suffered the crime. A family member all gets included under the federal definition, which is children that are underage or the spouse.
Oh, okay, very interesting, thank you. And Mr. Chair, one last question. Thank you.
Mr. Chair, if I can inquire, I think we're getting far beyond the issue of the disclosure relative to the bill, which I think is why it's here in this committee. We've heard this in public safety and other areas, and I think the classification of the data is really why we're here.
Keeping that in mind, Chair Scott.
Mr. Chair, thank you. And, well, this is the first time this bill's been before me. At what point in the process does there have to be an actual investigation of allegations of a crime for the U visa to be granted?
The U visa to be granted is all federal law. The signature recognizing that someone is a victim is up to the discretion of each police department, and it requires that someone either was the direct victim, indirect victim, or proximate victim. And all of those things, all of those definitions are quite complicated. But let's say that somebody broke my arm and I call the police.
Thank you.
I am the victim.
Representative Carlson has a question.
Thank you, Mr. Chair. Real quick question. Perhaps for the testifier, what's the average length of time in which to receive a visa?
Ms. De Leon.
The actual federal process or the signing of the certificate.
I guess both.
The certificates are usually signed within 2 weeks in Minneapolis. Minneapolis has 3 certifiers, and they're all well-versed in immigration matters. Across the state, I have seen visas signed within 3 to 4 weeks. Sometimes the chief of police is the certifier, and they can turn them around in a matter of days. With regard to the federal government, just to process the visa, it takes 4 years to get to the very first step, which is deferred action, and then it can take up to 15 years to receive the visa.
Chair Mariani.
Thank you, Mr. Chair and Ms. De Leon. I just want to be really clear about this bill, and we did hear this in my committee. This bill does not, in its language, grant visas to petitioners. Is that correct?
Ms. De Leon.
That is correct. This bill in itself only will give guidance, the way I see it, to different police departments for their signature on certifying that someone was a victim. The granting of the U visa is entirely up to USCIS.
And Mr. Chair and
Chair Mariani.
Representative Dehn, I've been involved in this issue for a number of years, and the issue before us in your bill is pretty clear, is that there's a requirement here for state law enforcement agencies to simply process a certification when it's requested by the victim. If we care about public safety, if we care about people who are being raped, sexually assaulted, or trafficked, then we should be supporting this. And so I really thank you for bringing this forward. I can tell you that over the years, what I've heard from survivors is, unfortunately, that there have been many instances where law enforcement entities simply did not respond. They didn't say no, they just simply didn't respond. And so that's all this bill does. I think it's a good bill for public safety and for justice, and to stand with survivors of, particularly of sexual assault in our society. And Mr. Chair, I feel so strongly about this, I request a roll call on this.
Roll call's been requested. Chair Johnson.
Chair Lesh, to the testifier, you had mentioned the somebody breaks an arm. I'm trying to remember when you heard this earlier, I'd looked up the qualifying criminal activity under the federal law, and it's very limited. I was wondering if you could actually provide the committee with that information and testify that this bill does not go beyond that.
There are 20.
Mr. Leon.
There are 21 enumerated crimes, and then there is also a provision for similar criminal activity. And among the enumerated crimes, there is sexual assault, kidnapping, blackmailing, trafficking. There's 21, and they can go into assault, or criminal sexual activity, or unlawful restraint, and they're very specific. When we submit a U visa, we have to use the Minnesota criminal statute under which this crime would fit. Let's say simple robbery does not fit the federal definition.
Thank you. I can't see your face, Representative Johnson, so did you have another question relating to the data provisions?
Not at this time.
Okay. Representative Lucero, do you have a question relating to the data?
Thank you, Mr. Chair, and to the bill author or testifier. Would an ICE official be able to deport somebody within the 14 days of being given a U visa?
So that was a no. You don't have a question related to the data provisions, right?
What's talking about disclosure?
To the bill, Mr. Chair.
Well, this has been heard in public safety. How many committees has this been heard in, Representative Dehn?
Mr. Chair, Public Safety is the committee it's been through.
Okay, well, what your question related to, your question was a yes or no question, was that right, Representative Lucero?
Correct.
Okay, if you answer a yes or no question, go ahead.
The U.S. ICE, which is not USCIS, generally will hear from us attorneys saying we have requested it, and we can do a number of things to prevent removal while we are waiting for the U visa response.
Okay.
It's likely ICE takes a position they do not deport victims of crime, but they do not want to wait endlessly until we are able to file something. They want us to act promptly.
Is that yes or no?
Was that a yes or a no, Ms. De Leon?
It is not a yes or no
You can
question.
get a yes or a no. There being no other questions, the motion is Representative Considine that this be recommended to be re-referred to Ways and Means. I'm sorry, Cantrell. Okay, it was Representative
Mr. Chair, I believe it's as amended.
As amended. Thank you. All in favor? Oh, wait, did someone call for roll call? Yes. We did, okay. Chair votes aye.
Representative Mueller?
Yes.
Representative Scott?
Nope.
Representative Barr?
Nope.
Representative Cantrell?
Yes.
Representative Carlson?
Yes.
Representative Considine?
Yes.
Representative Grossel?
No.
Representative Hassan?
Yes.
Representative Herr?
Yes.
Representative Johnson?
No.
Representative Liebling? Representative Lucero?
On this yes or no question, no.
Representative Mariani?
Yes.
Representative Noor?
Yes.
Representative O'Neill? Representative Robbins?
No.
Representative Zhang?
Yes.
Vote of 10 to 6, the motion does prevail. Your bill
Thank you, Mr. Chair.
Thank you, Representative Dehn. Representative Mariani, House File 2709. What's the motion?
Thank you, Mr. Chair. I would move that House File 2709 be referred to the Committee on Ways and Means.
That is the motion to your bill. And you have a DE amendment, is that right?
Mr. Chair, I would move the DE 6 amendment.
I'm sorry, which amendment are you moving, Chair Mariani?
Mr. Chair, I would move the DE 6 amendment.
The DE 6. Does everyone have a copy of the DE 6? Okay, all in favor to get the bill in the shape the author so desires. All in favor say aye. Aye. All opposed say no. Motion passes to your bill as amended. Chair Mariani.
Mr. Chair, I'll try to be as concise as possible. We have an important ability to increase police professional standards based on what this legislature has identified, quite frankly, in a bipartisan manner. that is most important to them relative to the kind of things we expect our peace officers to receive training in. Within the last biennium, we took actually 2 bienniums, we took special steps to identify implicit bias, mental health, de-escalation, knowledge, and training opportunities for Minnesota's licensed police officers in response to a number of tragic incidences that all of us were receiving from constituents. Mr. Chair and members, let me just state right off the bat, this bill still needs some work, and so I'm going to be very transparent about being upfront about that, and I want to identify where that is. But quite frankly, given the importance of this legislation, given the opportunities before us, and frankly, given the nearing, committee deadlines, it's important that we hear these provisions here today in Judiciary. I will continue to hear this bill in the Public Safety, Criminal Justice Reform Committee and work with members and interested constituents. House File 2709 has data collection reporting provisions that are related, as I said, to the legislative direction that a portion of the mandated training for peace officers licensed through the Pulse Board be provided training in implicit bias, de-escalation, and mental health. That $12 million biennial appropriation for that training component of our overall training mandates is set to sunset after the next biennium. We'll talk about that in the subsequent committee. But the idea here, members, is to have this bill tie ongoing funding to participation by our CLEOs in a data collection process that will measure the effectiveness of the training that we're spending a lot of money in. The bill then does that through data collection identified in 4 broad areas. Traffic citations, where we're looking for a designation of ethnicity. Peace officer discipline findings, where we're focused really only on major discipline issues, not small minor discipline infractions. Use of force data that the BCA, Bureau of Criminal Apprehension, already requires, and then participation in the unfolding NIBRS reporting system. NIBRS is the National Incident-Based Reporting System that will retire the summary reporting system, which has stood as our uniform crime reporting framework in our nation for decades. NIBRS will make it, the intent is to make NIBRS the only nationwide format for crime statistics in the U.S. It allows policymakers and law enforcement and communities to go much deeper in terms of that data for use in enhancing our public safety efforts. It does that by providing circumstances and context for crimes. It's going to be a useful statistic for promoting constructive discussion going forward in this legislature and legislatures across the nation. So with that, Mr. Chair, there's data collection reporting provisions throughout the bill, Section 1, which speaks to traffic citations, Section 2, which speaks to the discipline findings, Section 4, which speaks to the use of force data that the BCA already requires, and then Section 3, where we make an appropriation for a research entity to work with the Pulse Board to develop common measures based on the data, provide data-based information for enhancing CLEO decision-making, and frankly, to make sure that when we're looking at this data, we're able to compare apples to apples. As I said when I started, there are areas that I want to continue working on. It would be my hope to be able to do that beyond, after this committee, but then also if the chair is open and the committee is interested, to bring that back in the form of language as this committee then marks up as omnibus, so that everyone is fully informed of what our changes to data collection and reporting would be. The 4 areas that I intend to work on is in section 1. We didn't quite draft this right. It's not our intent to have ethnicity marked on a traffic ticket. It's our intent to have the perception of the officers stop and making this, and that citation be reported. We want to make sure that we're addressing concerns that Minnesota Police Officers Association has raised relative to the information about name and badge number of a peace officer who's party to the discipline reporting. We think there are ways in which we can anonymize that. Quite frankly, that information is public data as it exists at the local, at the CLEO, but they have some concerns about when we pull it together into, at the poll sport, even though we're calling for summary data reporting to the public based on that information. There's a question about where the database will be housed. I'm having conversations with the BCA about that. The bill as it's structured implies that it'll sit at post board. I think that would be ideal, but frankly, post board has some severe limitations. They're using paper for collecting data, not digital at this point. And so one of the other possibilities is to have the data reside with the research entity for a period of time. And the research entity we're interested in, quite frankly, is the Wilder Foundation, who I have here, can speak quickly about that. Very experienced in holding data for a number of state mandated projects, totally following our confidentiality and privacy statutes. And then finally, there's some issues in working with the BCA relative to the level of NIBRS data reporting when it comes to the level B category of offenses. And so they're still working out whether or not we can include those category Bs within this data collection scheme. So with that, Mr. Chair, I'll stop and perhaps allow, with your permission, Mr. Matisich to speak briefly about the Wilder Foundation, and this will be to the issue of the data collection and construct and issues about confidentiality and privacy as well.
Thank you, Chair Mariani. Welcome to the committee. Please introduce yourself for the record and begin your testimony.
Okay. Thank you, Mr. Chair, members of the committee. I am Paul Matisich, the Executive Director of Wilder Research, which is part of the Wilder Foundation. Wilder Research is a nonprofit, nonpartisan research organization, and we appreciate that many of the legislators here in Minnesota from both parties and their staff make use of the resources that we provide. I'll just speak briefly to the data collection and mechanical and confidentiality issues that Representative Mariani mentioned. We have projects such as Minnesota Compass, which is a website providing social indicators. We have carried out projects which require a high degree of confidentiality of information. In this particular case, what we would propose to do would be to develop a systematic, reliable, confidential compilation of the data in the areas that Representative Mariani listed. And in the tip of the iceberg, create two main functions, two things. One would be public-facing aggregate information that could be used to see trends in these different areas, something that any jurisdiction could use, legislators could use other policymakers, decision makers, to see what the overall trends are with respect to these issues. The second part of it would be information that would only be available to particular jurisdictions, police departments, that they could use for their own development, training, monitoring over time, improvement of their services. Our goal in all this is to improve relationships between law enforcement and community organizations, improve trust, improve understanding of the context in which law enforcement is occurring, what drives the outcomes of that particular context, of those contexts, and to be sure that we incorporate all the stakeholders who are relevant for deciding about this, how it should be measured into the process. So the last thing I would say is that as we would develop any form of a database, we would begin with a process in which a multi-partisan, multi-stakeholder group comes together. They identify what would be valid, reliable, credible indicators speaking to the topics that Representative Mariani mentioned, and then we would develop a scientifically credible way to collect, protect, and secure and report those indicators. Again, at an aggregate level, to anyone who's interested, and then at a more detailed level to particular departments who already would have the right to access that information. We've done this with the Minnesota Student Survey. We did this when we developed a homeless management information system for the state of Minnesota, which accessed data from homeless service providers throughout the state. In all these cases, it's highly confidential data, it's protected health information, and it's something that can be securely, systematically compiled and used for decision-making to improve law enforcement, to improve community relations, to improve our communities. So that's enough to say about it. I'll conclude.
Thank you. Any other
Mr. Chair, I would
Chair
only
Mariani.
add very quickly that we've been working on language pretty furiously for the past several weeks with a number of important stakeholders. I'm not saying that they're supportive, but I'm letting folks know that there has been a pretty rigorous process of interaction with the BCA, with the Pulse Board, with our chiefs, with our sheriffs, with the MPOA, and with our advocates, particularly in the mental health advocate community and our sexual assault survivor community as well.
Thank you. We have, testifiers, Mr. Hutton and Mr. Gottschalk. Please come forward. You can keep it, if you can keep it to within 2 minutes, thank you.
Absolutely. Mr. Chair,
Oh, Chair Johnson?
since this isn't basically a whole new bill, I'd like to have testimony go longer than just 2 minutes from this testifier, because this is a lot of information we do need to cover.
Yeah, this is all going to be covered in public safety. The corpus of all this will be before Chair Mariani's committee. Go ahead, Mr. Hutton.
Good morning, Mr. Chair. It's still morning. And committee members, my name is Bill Hutton. I'm the Executive Director of the Minnesota Sheriff's Association, representing the 87 elected county sheriffs in Minnesota. I'm here to testify regarding, for the sheriffs, regarding House File 2709. First, we'd like to thank Chair Mariani for the conversation regarding this bill. There has been a very good exchange of ideas and information on the items within the bill, and we do appreciate the continued conversation. We've identified 5 pieces to this bill. The NIBRS compliant requirement. The Minnesota Sheriff's Association understands that law enforcement agencies are required to be compliant by 2021 through the federal government and within this bill. Minnesota law enforcement continue to work with their records management system vendors to make this a reality, but nothing is ever easy with IT projects. As we are all aware, they typically are not delivered on time, without issue, or within budget. This, meaning the changing to NIBRS, is an expensive project for the counties. Use of force reporting through the BCA, this is currently ongoing. We do know that more work needs to be done and completed within law enforcement by way of educating on the reporting process. We also know that this reporting is relatively new. Post-annual data reporting, more review of this is needed. We do understand the need for a clearer statewide picture. Currently, law enforcement reports summary data to post of officer complaints on an annual basis. The reported data is not specific to an individual licensed peace officer or any specific complaint. The proposed bill requires that post publish summary data annually. Our suggestion is to let's agree on what data points are needed and report that information. Traffic citation ethnicity. The MSA does not support guessing on anyone's ethnicity. Guessing does not give anyone accurate or even good data. It potentially can place the officers in a bad situation as well. And fifthly, the peace officer training assistance. The Minnesota Sheriff's Association appreciates the monies that have been appropriated to the mandated training, but we continue to express concern that the monies have a sunset date. This bill adds to those potential mandates and has only delayed the sunset date. Again, thank you for the opportunity to address this bill, and we look forward to the continued conversation.
Thank you, Mr. Hutton. Mr. Gottschalk? Welcome to the committee. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair and members. For the record, my name is Matt Gottschalk, and I'm the Chief of Police in the City of Corcoran. I'm testifying today on behalf of the Minnesota Chiefs of Police Association, and we thank Chair Mariani for bringing this proposal forward and engaging with our association on the front end, as working through some of the language. And we look forward to working with the legislature as this proposal goes forward. But we have some questions and concerns about the proposal as it's currently drafted. There are some good points in this bill, and we support working towards things like getting our agencies, NIBRs compliant, but there are some hurdles, as Sheriff Hutton mentioned. The bill currently draws some very isolated statistics and at the same time puts an end date on the funding for law enforcement's robust training requirements relating to diversity and cultural differences, conflict management, mediation, crisis intervention, and some mental illness crisis. It goes on to add a host of other unfunded reporting mandates and contains some significant language that still needs more consideration. While the intent to gather ethnicity data on uniform traffic ticket is noble and would apply to actual tickets, it puts officers in a terrible position to take an educated guess as to an individual's race or ethnicity. And this has potential results of adding another barrier to our positive community interactions. We also feel the discipline data report language needs some work. The current bill language sends full complaint data to the post, and we feel summary or aggregate data submitted to post board would be more appropriate. Also, most complaints actually come from within the law enforcement agencies in holding officers accountable. The bill as drafted doesn't even allow agencies to indicate that a complaint came from within the agency to show that our officers and agencies take discipline seriously. It simply says a complaint came from either a member of the public or other sources, and the other source most times is our agencies. Furthermore, while this data would be classified as private data, our association will remain concerned about the security of that type of sensitive personnel data being housed in a database run by a community-based research organization, which could be prevented by simply reporting aggregate data to the post board. Lastly, I want to reiterate that while this committee is primarily concerned with data provisions of the bill, the training reimbursement is tied to compliance within the bill. The message that we are sending to our state and to law enforcement by continuing to sunset this important training funding is disappointing. When the Law Enforcement Coalition came forward with the training proposal a few years ago, we knew the need for this training and that it needed to be a long-term investment, and sunsetting this funding is not something that we can support. Thank you.
Thank you. Questions from members? Chair Scott.
Thank you, Mr. Chair. And Representative Mariani, I appreciate your openness to make changes in this bill as it goes along, and particularly in relation to data, especially if it's going to be housed at a third party. There are some parameters that I think you'd want to put around that data. I think you need to determine, first of all, how long the data is going to be kept. And then also kind of some of the things that we've been putting in anytime there's a new database or whatever is role-based access and what else? Audit trails, those sorts of things should be built in so that we know who's been accessing the data. And I see the representative from the Wilder Foundation has come up, and perhaps he can speak to those things. But those are just some of the parameters that we've been putting in surrounding new databases that are created. Thank you.
Thank you. Representative Lucero.
Thank you, Mr. Chair. And my first question here, either to the bill author or maybe to research, would be when looking at line 1.12, it says the new language is must identify the complainant's ethnicity. But then when I look at the handout that we were given from regarding the Wilder Foundation, in the first paragraph, there's a footnote to Minnesota Public Radio article in regards to Minneapolis that they were tracking race. So my first question is, can we confirm the difference between race and ethnicity? And then what is the definition of ethnicity as it is in the bill language?
Chair Mariani, did you want to take that or research?
Mr. Chair and members and Representative Lucero, we've struggled a bit with this because we have different jurisdictions that are using different descriptors based on what we're interested in. And so the court is using ethnicity descriptors. NIBRS, I believe, uses race descriptors. What I'm learning as I interact with the BCA is that the race descriptors in NIBRS are limited relative to the court's use of ethnicity. So Latinos, for instance, are going to be lost in the NIBRS reporting at the highest level, where that'll be evident in the court approach. So quite frankly, this is one of the areas that I want to continue to work on, to settle on. But my intent, quite frankly, is to have as inclusive as possible a descriptive framework, because that's what it's going to take for us to be to get to the ultimate intent behind this legislation, which is to provide a data-based framework and analysis of that framework to enhance the practices of our law enforcement community.
Representative Lucero.
And Mr. Chair, to you then, did I understand you correctly that this is going to be going to public safety?
Yes.
Okay, I'll save the rest of my questions for that committee. Thank you.
Thank you. Representative Grossel.
Thank you, Mr. Chair, and to the author as well, in reference to the ethnicity or the race that they want to keep track of. Every time I see that, it just makes me cringe, in all honesty. It makes me cringe because the Commissioner of Public Safety, when he was in front of our committee in public safety, flat out said that we are to execute our duties in an unbiased manner. That is what law enforcement's job is. That's the way I do things. That's the way every officer that I've ever known does things. And when we start keeping track of ethnicity and things, it makes me think that are we wanting to start a racial profile data bank someplace? When I see those kind of things, I don't like it, because I don't want to put our officers in that position. Can you say something to that, or is there a way that that you can take and get rid of that? Because
Mr. Chair and Representative Grasso, we'll have a longer debate in the next committee, and it should be a welcome debate. The commissioner also said, when it was before us, that racial bias is a problem. It's a reality in society. It's a reality that impacts law enforcement. The current minority party in the House, when they were in the majority, understood this, and so former Chair Cornish was part of one of the architects in directing the training dollars to be able to address implicit bias. And the question then becomes, how do you address implicit bias if you're not collecting data about that bias? I think the issue, and again, I want to be very transparent, the issue relative to Section 1 in this bill is that I think what I've done with this language is place that identification in the traffic citation itself. That's not my intent. And so, so I'm putting on the record that, my intent is we'll have to find another way to be able to have a checkoff, for the citing officer to be able to register their observation that's independent of the traffic citation itself. I think at that point, then the issue that you're raising becomes, compounded. If you're getting cited and the citation says, basically, I'm citing you because you're black, that's not what the intent is. And so we'll fix that for sure.
Mr. Chair.
Representative Grossel.
Thank you, Mr. Chair, and thank you, Mr. Chair, for looking closer at that, and I'm wondering, because of what the commissioner said, the racial bias in society, I hear a lot of things coming forward. We need to make our cops better. We need to make our cops better. I was one, and I've always advocated, we need to train hard, we need to do it right. We need to be the best officers that we can be on the street because we're representing everybody. And our officers are represented by every race, creed, color, gender. I mean, we're all out there, and we're all out there trying to do the best that we can to support our communities. You and I have had conversations offline just on where we come from, how we were brought up, and the things that we see, the direction that we see society going from time to time it's not a good direction. So I take a step back to ask, is there anything being done to monitor the trends of the general population, the general public, to improve the communities, to improve the community's outlook or their approach to law enforcement officers? If we're only asking the officers to step up, but we're not asking the community to take a hold of your young people, this is how we need to do things. If we want everybody to work together, that's my goal. That's always been my goal as a peace officer, to make sure that I'm a representative of them, to build relationships with the community. But you and I both know that if the community is not building relationships to build bridges to improve relations with law enforcement, we can train until we're blue in the face, and it's not going to amount to a hill of beans.
We've got two more people on the list. Members, keep in mind that this committee shares 9 members with public safety, and the basic policy of this bill is going to be heavily decided in public safety. We're here on the data practices component. Representative Muller.
Thank you, Mr. Chair. And with that, I'll keep my comments short, but just to kind of address what Representative Grossel just said, too. So I think everybody on the committee knows that I'm a prosecutor. I work at Hennepin County. And I took implicit bias training as part of my job there, and it was life-changing for me and for some of my colleagues. And so, but I guess my question for you, Chair Mariani, is just because I'm new here, and I don't know how the original training dollars came about, and I think you've mentioned that, but I just want to be clear that those initial funds in part were to provide implicit bias training. Am I understanding that correctly?
Chair Mariani.
Mr. Chair and Representative Muller, yes, along with de-escalation and skill enhancement in dealing with mental illness as well. And by the way, members, we'll talk about this in the other committee, but the sunset was created at that point. This bill actually extends the sunset out a bit. There's still a sunset, but we're not creating the sunset. I know that's outside the scope of this committee, but yes, Representative Muller, that's correct.
Thank you, Mr. Chair. And I would just say I look forward to a broader discussion of this in the Public Safety Committee, and perhaps we can talk a little bit more about implicit bias too, but it does apply to all people. All people have implicit bias, no matter what race or color you are. So thank you.
Indeed.
Representative Johnson.
Chair Lesh, Representative Mariani. My comments were partially on what we've been talking about, the officer trying to guess which the ethnicity I can try to guess what Representative Lesch's ethnicity is.
You'd be wrong.
I have a good idea because of the items he's brought in that he's probably some Irish in him.
Stubborn.
But everybody has ethnicity. I'm Swedish and English. I have Representative Lusaro's. I have no idea what he is. And by some of the suits, we don't know either. But trying to get ethnicity is not the way to go about this. Law enforcement officers do the stops and the citations on probable cause. They have to have probable cause in order to make a stop or make an arrest. Without probable cause, their arrest is not good. And if they get a number of citations or convictions thrown out because of lack of probable cause, they're generally shortly done being an officer. So the officer is very careful and make sure they have proper probable cause before they issue a citation or make an arrest. Now on the back, there's a lot of issues with data privacy on this disciplinary report. And I'm hoping Post Board comes up in a little bit to talk about this as well. There's a lot of departments, about 40% of our departments have 5, 6, 7 officers completely. And as the gentleman from the Wilder Institute said, they can get the data down to the department. You have a 3-man department, and all of a sudden an officer is disciplined. They don't know, and that's a lot of that disciplinary is for, a lot of times, is for violations of policy. Nothing to do with the public, but a policy issue. That information, all of a sudden somebody sees, oh, he's not on vacation, he's at home, he's not working. A month later, they call Post Board to get the information on that department, a 3-man department. It's supposed to be confidential. Personnel policies are confidential. When an officer moves on to a different department, he signs the release so that department doing the background check can actually look into his personnel policy. This is very dangerous and can be very damaging to law enforcement and the public themselves.
Yeah.
I think we really need to take a closer look at protecting the data, how we disseminate it, what gets disseminated, and be very careful, because if we don't have our law enforcement, we don't have our liberties.
Mr. Chair.
I think Chair Mariani.
Very, very quickly, Representative Johnson, I think I partially agree. I would point you to, just so you know what the intent is here, if you look on line 3.22, it says that the data received in subdivision 1 is private data on individuals. It does go on to say that that doesn't restrict the publication of summary data. If you switch over to then line 4.1, in subdivision 6, it talks about the board publishing a summary of data, and then it goes on to say that the summary shall exclude peace officers' names and license numbers. So the idea is not to have that be the outward public face. The original intent is to have as much real data as possible so that internally we can have the kind of data-driven reflection and processes in order to continue to produce better decision-making on the part of law enforcement. The irony is, members, that at the CLEO level, this data is actually public. And so we're actually backing off when it comes to when we're pulling it together into a big database. It is the section I will continue to work with, as I mentioned earlier, but Mr. Matisich has, I think, a quick point he wants to make as well.
Just quickly, so Representative Mariani took care of the part of your question, I think, about individual data, which would not be revealed to anyone who wouldn't have a right to it. The other part of your question, which is a very important point, is that even summary data can can reveal things you don't want revealed if it's about groups that are too small. And so in any project like this, just as the Census Bureau does, or any other research organization, there would be minimums established as to the smallest units that could be described. And so a 3-person department, summary data wouldn't be presented for that. There'd be some kind of a cutoff. And that would be standard procedure to protect confidentiality and eliminate the situations you're describing.
Thank you. Chair Mariani's motion is that this be re-referred to Ways and Means. All in favor, as amended, we amended it, right?
Yes.
As amended. All in favor, say aye. Aye. All opposed, say no.
No.
Motion passes.
Thank you,
Representative
Mr.
Long.
Chair, members.
Representative Long, please have a seat. The motion on this bill is that it be laid over for what, possible inclusion? We're just going to lay it over, okay. So this is an informational hearing? Oh, I get it. Okay, members, so this bill is being carried in another omnibus bill. We are hearing it here for the data provisions. So go ahead, Representative Long.
Thank you, Mr. Chair, members. This bill deals with
One second. Chair Scott?
Mr. Chair, I had a procedural question, and that is, how does a bill that has to do with data end up in an omnibus bill before it comes to this committee? Mr. Chair.
Chair Scott, I don't have an answer for you.
Mr. Chair, I think this was done in a backward sort of way. And your bill evidently, to the bill's author, didn't meet deadline because it didn't come to this committee before it got thrown in an omnibus bill. So I would move to table this bill, Mr. Chair.
Well, Chair Scott, you can move to table it. I mean, you guys did this pretty routinely as well, too. We hear the provisions of the bill and move them through. If we have objections to that portion of the other omnibus bill when it's on the floor, you can move on the floor or in another committee to remove those provisions or make an amendment.
Mr. Chair, they didn't follow
Scott.
procedure. Mr. Chair, they didn't follow procedure with this bill.
Well, go ahead, Representative Lucero.
Just a question, Mr. Chair. So I'm just hearing about this now, that this language exists in an omnibus bill. So the question I would have, if we take any action on this, amendments, vote it down, whatever, does that have any impact on the language that exists in the omnibus bill?
Well, the specific rule in the Minnesota rules that were adopted, both temporary and permanent now, says that those provisions need to be heard in this committee. So that's what we're doing. We're hearing those provisions in this committee. Just because it's not heard as a separate bill and then doesn't follow a different course, there are quite a few ways to skin a cat here. So our action here does not modify language in another bill, be it an omnibus bill or another kind, but that's true for every single bill that comes through this committee or another committee, Representative Lucero. Go ahead, Representative Long. Oh, is you moved to table it. Okay, all in favor of tabling House File 2681, say aye.
Aye.
All opposed, say no. No. Motion does not prevail. Go ahead, Representative Long.
Thank you, Chair Lesh. Members, this bill deals with data access to utility data. With the increased usage of smart meters, our energy data is getting better and better. Nearly half of all U.S. households are now outfitted with smart meters, and that number is growing every day. This data is a public benefit. It is a resource for customers and a resource that can help energy stakeholders better understand our energy system. It can help us cut carbon pollution while keeping energy bills low. Currently, under Minnesota law, there is no requirement that utilities release energy use data to customers or third parties. Many utilities do provide access to their customers, but is at their own discretion. The Public Utilities Commission has a model data release consent form for individuals. It also requires that aggregated data adequately protect anonymity. This bill would provide access to energy usage data in 3 ways. First, customers will have access to consistent and reliable personal data regardless of where they live. This is their own data and they have a right to it. It will also allow customers to make better choices about their home energy use, to decide where to invest in energy efficiency, and to reduce their utility bills. Second, the bill reinforces the customer's right to give permission to third parties to access their data. This can be, for example, to ask for services that help them save money, such as installing insulation or customizing a solar rooftop array. This can be a job creator, giving energy services businesses new ways to help customers.
Third, the bill allows secure, anonymous, and disaggregated utility data to be made available to third parties for the purposes of research and development. We all want to respect customer privacy, and the bill has provisions in place to protect that. This research, for example, could be used by a university to study energy or by a city to help meet their sustainability goals. This bill is bipartisan. Representative Garofalo is a co-author with me, and with that, I will have my testifier present as well.
Welcome to the committee. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair and members of the committee. My name is Annie Levinson-Falk. I'm the Executive Director of the Citizens Utility Board, or CUB, an independent nonprofit advocate for Minnesota utility consumers. CUB represents residential and small business energy consumers at the legislature and before the Public Utilities Commission, and we work with consumers across the state to help people understand their home energy options as well as the broader energy system and energy policy. CUB's outreach team sits down one-on-one with individuals and families to walk through their energy bills and help them find ways to bring down their costs. This combination of work with people on an individual basis and at the policy level here in St. Paul leads us to support the bill before you. This bill will unleash the potential of energy data in a way that protects ratepayers. We're in the midst of hundreds of millions of dollars of investments in technologies like smart meters, which are generating much more data than was imagined when Minnesota's energy statutes were written. This bill will make sure that data is available to the consumers whose money is being invested. It will ensure that consumers in all parts of the state have access to their own data, whether they're in Minneapolis or in Leon Township, and it will allow them to share their data with a third party should they choose to do so. It will also allow third parties to access summary data, enabling groups like CUB to identify rate designs and programs to help people use the utility systems more efficiently, saving everybody money. Utilities have raised some concerns about privacy protections. Consumer protection is key to CUB's mission, so we've taken a careful look at those provisions. We want to be sure that anonymous aggregated data can never be reverse engineered to identify a particular customer. The bill adopts a 1515 standard, prohibiting the release of summary data with fewer than 15 customers, or if any single customer is more than 15% of the total energy usage. This is a more conservative standard than is being used in many places around the U.S., and including by some utilities here in Minnesota today. Moreover, if you look at lines 2.18 and 4.2, they explicitly prohibit the release of any summary data that could potentially be used to identify a customer. We also recognize that customer energy usage data is potentially really valuable. With the rise of companies like Google and Facebook, I think we're just beginning to understand the enormous value of big data. And I'll be the first to admit that I'm not a data geek, and I don't completely understand what values a company like that might be able to get out of customer energy usage data. But I am a consumer advocate, and I want to make sure that customers' data doesn't end up being used for profit in any way that might take advantage of Minnesota consumers. We don't believe that Minnesota law currently covers this topic. That's why it's important that this bill would prohibit a utility or any third party to whom a customer granted access to their information from sharing or selling that data. This bill would put in place baseline consumer protections to catch state statute up with the new world of big data. I thank Representative Long for carrying this important bill and would be happy to answer questions.
I have a question. What prohibits utilities now from operating as permitted by the language in the statute?
Chair Lesh, I'll speak to that. So utilities do share some data with their own customers, but it's inconsistent across the state, and there is no essentially right for a customer to have access to that data, which is something that this bill would provide.
As well as third parties having that right?
Correct.
Is that correct? Okay. Questions for the testifier? Oh, we've got two other people who are going to come up. Okay, come on up. Welcome, Ms. Pepin.
Shall I go? Well, good morning, Mr. Chair. It's great to be back. Members of the committee, it's always good to be in the House. I'm Joyce Pepin, and I represent the Minnesota Rural Electric Association and the 44 electric distribution co-ops and 6 generation and transmission cooperatives in the state. And I appreciate the opportunity to testify to the bill. The Rural Electric Association and our co-ops have several concerns with the bill. For starters, it places utilities in the position of managing the data authorization process. Electric co-ops already provide access to energy data to the account holder. Our current method ensures security and still allows consumers access to their own data. They can then provide the data to whomever they wish. Allowing third parties to request and gain access directly from the utility jeopardizes the existing security model. Section 2, Subdivision 4 requires utilities to prepare and make available aggregate summary energy usage data upon the written request of any person. Public access to the data creates a variety of potential issues. First, customers have not given their consent for their data to be used in any fashion other than for utility purposes. This section greatly expands who can gain access to the data. For example, could a tech company ask for the average kilowatt hour in order to target their products by zip code or by city block? I think so. Second, there is no clear direction on how a utility would aggregate this data, and regardless, such disclosure comes with great risk that the data could be unwound by sophisticated hackers to determine whether residential property is regularly occupied or what schedules residents maintain. Those are just a few examples, but the potential security risks are staggering. Third, the bill provides an unreasonable burden on utilities to provide an unlimited number of data sets. Many utilities do not have the capabilities to conduct this type of analytics and thus need to outsource the capability. This in turn moves the data one step further away from the consumer's control. Finally, this legislation requires utilities to implement risk management practices that include mitigating cybersecurity risks. They must protect against loss and unauthorized use, access, and dissemination of customer data, and must maintain a comprehensive data breach response system. How can utilities ensure customer data integrity in light of the fact that they will also be required to provide customer data to anyone who asks? How will utilities ensure that third parties that store data implementation risk management practices that meet the same requirement? How will small electric co-ops be able to do any of this without adding significant cybersecurity staff to ensure data protections, all without being indemnified? These are just a few of the questions that should be answered before the bill moves forward, and I ask you to truly consider the customers and what data you think that they would want anyone to have. Thanks for your time.
Thank you, Ms. Pepin.
Mr. Chair, members of the committee, I'm Ken Sewell with the Minnesota Municipal Utilities Association, and we're here to express some concerns of how this bill creates unique challenges for municipal utilities that are subject to the Data Practices Act. Because what you end up having with this bill is a double layer of procedures, and the procedures laid out in this bill are not all that clear. It must be convenient access to the customer. I'm not sure what convenient really is supposed to mean in light of the data practices procedures that are already in place. Are those convenient? I don't know, but they're statutory law, and so we'd have this conflict. You have, under the Data Practices Act, the data, most of the data in here in its raw form would be private data. Now it is being authorized to be released, but we must prepare and make available this data that they're asking for. So it's a new requirement to manipulate the data and create a new format for it. I do not see anything in this bill that limits it to just research. I believe that was part of the earlier testimony. I may be wrong, but I find nothing that limits the use of this data or who gets to ask for it. In light of those problems that are in place in the conflict with the Data Practices Act, we ask that you give serious consideration to this bill, that it simply is not ready, whether as the standalone bill before you today or as part of the Omnibus bill, which we would encourage you to pull into this committee if it continues to move with its provisions of this bill. So with that, I'd be happy to stand for questions.
Okay.
Mr. Chair,
Mr.
if I may, one additional issue that's questioned in here is under data practices, we have the ability to go to the Department of Admin, to the iPad division, and seek advisory opinions and get guidance as to whether we're doing things the correct way. Here, there's no such provision. The Department of Commerce, apparently the commissioner can come after us if we're not doing it right, but there's no pre-advice. And if we end up with a conflict between the Department of Admin and iPad and the Department of Commerce, I don't know if they settle it by a arm wrestling match or what, but we would be caught in the middle. So just one more unique provision as it relates to municipalities.
Thank you, Mr. Soom. Is there anyone else in the audience who is here and wishes to be heard on House File 2681. Member questions? What? Oh, Representative Lucero.
Thank you, Mr. Chair, and I've got several here. The first is I'm looking, or a point of clarification would be to the bill author, and that would be, is all of this information in our customers going to be, is this an opt-in or opt-out? So is data going to be available unless they affirmatively opt out, or is it currently unavailable and they have to affirmatively opt in?
Representative Long.
Mr. Chair, Representative Lucero, this is all opt-in. This is all at the request of the individual utility subscriber.
Representative Lucero.
Thank you, Mr. Chair. And then to that point, when I look at lines 3.26, does that include subdivision 4, whereby if I'm a customer, can I choose not to opt in to that which must be made public?
Representative Long.
Mr. Chair, Representative Lucero, so subdivision 4 is not specific utility data to any one customer. It is anonymized, aggregated data. So there would not be any ability to determine any individual customer's data with this. And the provision that protects that is that you can't request data from any fewer than 15 customers, and no single customer can use more than 15% of their data, which, as the testifier spoke to, is a very conservative standard.
Representative Lucero.
Okay, so just to clarify what I heard then is that I, as a customer, I don't have the option, even though it's not PII, personally identifiable, if I, as a customer, don't want to participate in my data being part of this provision, I don't have that option if I understood correctly. So then the next question I would have is when I'm looking at line 2.6, the definition of customer data means all data a utility collects, creates, receives, maintains, etc. So I am a landlord and I have multiple properties. I, as the landlord, I receive, it's just the equivalent of an FYI card on all of my tenants so I can see what their bills are and their usage. Do I, as a landlord, have the ability to override, well, if my tenant chooses to opt in, can I choose to opt out?
Representative Long.
Mr. Chair, Representative Lucero, I'm not sure I understand the question, but this only applies to utilities, not landlords.
Sorry, Representative Lucero.
Mr. Chair, to clarify my question, a customer of a utility who chooses to opt in, that is the tenant of a property, can the landlord choose to not have their property be part of this that the customer might have opted in?
I see. Chair, Representative Lucero, and the provision you're talking about is subdivision 4? Or are you talking about the entire
whole
bill?
thing.
Okay. So the customer data under this bill belongs to the customer, to the individual who's subscribing to the utility. So it would be their own data, and they could request access to it, or they could give it to a third party if they so chose. The landlord wouldn't be able to impact the individual customer's data, from my understanding. And then for the subdivision 4, I think the answer that I gave before speaks to that.
Okay, Mr. Chair.
Representative Lucero.
Thank you. And so then if I, as a landlord of a property, that if I don't want my property to be part of this program, I would not have that option to not have it participate, I guess is the point. Then the last question I would have is when looking at line, beginning on line 3.18, there is the option to revoke authorization at any time. Does this revoking of authorization then, is there any provisions in here to include that third party that might have collected data or had access to a customer's data to that point that is then revoked to purge that data that they might have collected or had access to and saved? And then if there is, what is the time frame to purge that? And then what is the penalty if there were any breach of that data of the third party?
Mr. Chair, Representative Lucero, that's,
Representative Long.
I don't believe we address purging in the bill.
Representative Lucero.
Would you be willing to consider adding some provision that revoking access means that if it's silent, revoking access would be going forward, but would not be retroactive to access to the data already collected?
Mr. Chair, Representative Lucero, I'd be happy to work with you on that.
Okay. Representative Robbins.
Thank you, Mr. Chair. To follow up on one of Representative Lucero's points, I didn't see where the opt-in is. I saw the revoke language in 3.18, but where does it say the customer has to opt in? It made it seem to me when I read it that all the customer data would be available to these third parties unless they opted out.
Representative Long.
So Mr. Chair, Representative, line 3.8.
Oh, okay,
If a
perfect.
customer provides authorization.
Perfect, thank you. And then my second question is in sub 4, in the section B, talking about the 15 customers. As you read through that, at 4.1, it says, summary energy usage data may be disaggregated on a per customer basis, provided the customer's identity is not ascertainable. If we're talking about 15 people in a very rural section of my district in Hassan Township, I'll bet anybody on that block knows who those 15 people are. So I'm just wondering, how can you disaggregate to the per customer basis, but their identity is not ascertainable? How do you achieve that?
Representative Long.
Mr. Chair, Representative, so it's specific that you're not allowed to provide any identifiable data along with it. So you can't attach, for example, the name or the address or any information along those lines. You have to have the 15 and 15 to make sure that there's no individually identifiable data. So those are the protections in there for folks on your block.
Thank you, Mr. Chair. If I might, so what would it mean that the data be disaggregated on a per customer basis? What would that look like?
Representative Long.
I'll ask my
Ms.
testifier to speak.
Levinson-Falk, is it?
Yes.
Okay, go ahead.
Thank you, Mr. Chair. And Representative, I think that's a really good question. What it means to have a disaggregated set is you have kind of like lines of individual customers' data, but you wouldn't be able to tell who those customers are. This is modeled on how it's done in Illinois. We have a kind of a sister organization in Illinois that receives data sets of, say, 300,000 customers and then is able to do rate design modeling or different programs to see how individual customers or types of customers might be impacted by different utility offerings. So that's how it would look. I'm imagining, an Excel sheet with 300,000 different rows on it, or fewer in your example. I think if there is a case where you have a small enough subset of customers that has been requested, that you would be able to potentially, if it's kind of a reasonable assumption that you might be able to identify some of those customers, that's a data set that the utility wouldn't release under this bill, but because of that provision that you read.
Representative Robbins.
Thank you, Mr. Chair. So just to clarify, how is it clarified in your mind that, because it says no less than 15 customers, so if you're at 15, that could be released under how I read the bill language?
Mr. Chair and Representative, that language applies to kind of two different types of data that could be released. There's an aggregated data where, say, you have a large building or a block and you want to just see the total aggregation of energy use in those customers where they're not broken out. I think when you have a 15-15 standard, that's quite a conservative approach to that and probably wouldn't pose that kind of a risk. The other type of summary data that we're talking about is that disaggregated, where 15 customers could potentially, I think, be too small of a data set to release, and the way that I read this language would not be allowed by this bill.
Thank you, Mr. Chair. I have one more question, but then I would like to ask one of the testifiers to just come and speak to that. But my last question is back to the security of the data by the third parties. Is there any provision that sets standards for them, and is there any reach back to the utilities if the third-party data is breached? Is there any liability on the part of the utilities?
Mr. Chair, Representative, there is, if you look at 3.23 to 3.25, third party are subject to the data security and privacy requirements under subdivision 6, so they're held to the same standards as the utilities. The bill doesn't speak to liability.
And so if there is a violation, I'm sorry, who is on the hook if there is a violation of that data privacy?
Representative Long.
It would be the same as in current law. This wouldn't change the ability to go after folks for violations of data privacy.
Thank you. Mr. Chair, if I could have the testifiers come back and speak to both of those questions. Thank you.
Thank you for your questions, Representative Robbins. I have several thoughts. And first, I didn't point out in my earlier testimony, but This is such a complicated issue. This was an open docket in front of the PUC for years. There was a report on it, and it was, I can't remember how many pages long. I think I made it through maybe a tenth of the way through, and once I got to about a page 50, I stopped reading. It was hundreds and hundreds of pages long, and it didn't come to a conclusion. And that's because of exactly the issues and the complications that you're talking about. I think just a couple of the comments. I think 4.20, data security and privacy, this puts the onus on utilities. So you've got some utilities that are very, very small, and now there's nothing in here that indemnifies them. They're supposed to, they have to put systems in place to make sure that they maintain all this customer privacy and that, that they're guaranteeing that there'll be no breaches. But yet, there's no way to know how this is done. It's not laid out in the bill. It's not clear, and this was one of the big hangups in the PUC docket as well. So I forgot what your first question was, Representative Robbins. I can't remember what the first question was.
I'm sorry. Sorry, Mr. Chair. Just speaking to what it would look like if as in 4.1, the data is disaggregated on a per customer basis, but the customer's identity is not ascertainable. I'm not sure that that would be true in all cases, especially in very small data sets.
Yeah. Thank you, Representative Robbins. I think that is a concern. And also, if you consider, I think our big concern is that there are a lot of people that are very sophisticated. There have been data breaches in ginormous companies. And so when you take this data and I'm not a cyber person, but if you are able to get other data, you're going to be able to get a lot of information to build a profile on a customer. I think that's very, very problematic, especially in rural areas that don't have access to a lot of the stuff. And then I would just also say to a lot of the other questions talked about opt-in and opt-out, and I think that there was a lot of direction to the first part where it talked about customers' own data, but the subdivision 4 part, there's no opt-out available. To Representative Lucaro's question. So to me, it looks as though there's no way for anyone to opt out of this. If I say I want to know, I know you have, for example, 15 properties and I want to get the energy usage data, I don't see anywhere where it would prevent me from getting that. And it doesn't have to, it could just be me. I can just call and it can be anyone because it says any person in the bill. So a lot of things to be very concerned about in the bill. Hope I answered your questions, Representative Robbins.
Do you have a last question, Representative?
I'm all set. Thank you.
Okay, thank you. Representative Barr.
Mr. Chair.
Thank you, Mr. Chair.
You've got an amendment.
Yes, I'd like to offer the A1, please.
Okay, Representative Barr offers the A1 amendment. Go ahead.
Mr. Chair, the A1 amendment effectively does two things. It exempts the municipal co-ops, municipal utilities and the co-ops, and then in the language 1.3 on the amendment makes it after the comma inserting as defined in section 216B02 subdivision 4. That makes it basically investor only utilities. So the like XL Energy would be an example. And then the last piece down here removes subdivision 4, which both testifiers have talked to, and the questions have all been around the security on subdivision 4. And the reason I remove subdivision 4 is not only, I can see the advantages of somebody like Cub coming in and using this data to try and make our lives better or steer individuals with energy conservation programs. But I can also see other utilities or other businesses come in and use this data detrimentally. So let's say XL Energy wanted to try and buy a municipality. They could come in and request the data on the whole muni or the whole co-op and then come in and figure out can they make a bid on this or can they not make a bid on this. With the 15%, you could take a chunk of data and request a certain area here, and end up with an overlapping piece in the middle to isolate certain chunks just by requesting different data sets and overlay it. And we've seen some amazing data dissection with Google and companies like that. So that's, I don't think there's nearly enough protections on this for any private company to protect any of their any of their usage datas from being bought or tried to be bought. Pick any heavy utility, a paper company, a mining company, anything like that that has heavy electricity or heavy utility usages. Their competition could use this data to figure out whether that was ripe for a hostile takeover or something like that. So that's why I wanted to remove subdivision 4. And then lastly, with the municipalities and the co-ops, we've already heard from both of those organizations that they really don't have, they're not set up to handle this, and that they're entirely too small. That data belongs, and in the case of a co-op, that data actually belongs to each individual member of the co-op, not the entity itself. With
Thank
that,
you, Representative Barr. Any other comments to the A1 amendment? Representative Long?
Thank you, Mr. Chair. I oppose the A1 amendment. I believe that all Minnesotans deserve access to their data, and this would prevent that. And I think that the 1515 standard is a conservative one. The Attorney General's office was involved in the PUC docket, and they were there on behalf of consumers, and they have notified me they believe this is a conservative standard as well.
Mr. Chair?
Mr. Sulam.
I had a couple of answers to the questions that were asked that may affect the amendment as well, if I could take just 30
Well, you're
seconds.
supporting the amendment, right?
I believe I am as the exemption, but there are still a couple of questions that I think that the clarification would help the committee, if I could answer some clarification to the questions that were asked.
I don't think he asked any questions. He was just making a
Chair.
point. So, Representative Lucero.
It was to the questioning of myself and Rep. Robbins. He attempted to speak, but you didn't see his hand. I think that's what he's referring to, prior to the amendment.
Okay. Yeah, I don't think so. I think we're just going to move on. And this is member discussion on the amendment, and we'll entertain Representative Long's comments on that. But any other comments of members on the amendment, or if people do have questions on it, they can ask it. Chair Johnson.
Chair Lesh, I have to speak in favor of this amendment because it's dealing with the co-ops. The co-ops are private, are owned by their members. So the information that on that member's information belongs to them. It doesn't belong to the co-op. It belongs to the individual that is the owner of the co-op. And this does address that issue because it's a data privacy issue for the individual. Now, this is making the individual homeowner can fall under this.
Thank you. Chair Scott.
Thank you, Mr. Chair. I would like to hear from Mr. Solomon before I cast my vote on this amendment, because I feel like the more information I have to base my decision on, the better. So.
I'm not going to let him go on whatever he wants to talk about. If you have a question for him, Chair Scott, ask him the question.
I think it was determined before that he was unable to give information leading up to this amendment, that he had information on 2 previous lines of questioning. And so I would just ask him to be able to elaborate on those issues.
I'm not going to have anyone elaborate. If there is a question that someone has for Mr. Sulam, ask him the question. Representative Grossel.
I guess I'll just ask Mr. Our presenter there, please share. My question is, what did you have to say?
No. If there is a question for Mr. Sulam, you can ask him the question. That's right. Representative Lucero, we're not going to.
I do have a question.
Here's the deal. Here's what I'll tell you. Representative Barr, I'm going to support your amendment, okay, because I think it's important. You're still going to lose because it's going to go down 7-7, okay? If you think that you have something really persuasive that you can get someone else on this side to go with it on, go with that. Otherwise, we're just spinning our wheels in the mud. Go ahead.
I'll make it real quick, and it's to that point, and it is relevant, and something that Rep. Barr brought up in his speaking about the amendment is, when I'm reading the subdivision 4, anybody upon request can ask for the summary data. The requester then would have to specify what their geographic area would be, right, is my understanding. And then, so there could be repeated requests. So I envision an area, let's just say 500 homes, and then the requester could ask for that. Then, as long as they meet this 15 or 15% requirement, then they could shift it over ever so slightly, the geographic area they're looking for, and then shift it over again and shift it over again. And by doing so, they might be shifting it over 1 block or even half of a block, 1/2 of one side of a street. And they do that, and after sufficient requests, they then have achieved down to a very narrow area. And so to that point, it does expose and allow somebody, any requester, as it's defined here, any requester, to get down to a very granular data, which is a high concern. So in that respect, I would highly support Representative Barr's amendment.
Okay.
I'd like to ask for a roll call.
Roll call's been requested. All in favor, the vote on the A1 amendment. Chair votes aye.
Representative Mueller,
No.
Representative Scott,
Aye.
Representative Barr,
Aye.
Representative Cantrell,
No.
Representative Carlson,
No.
Representative Considine,
Pass.
Representative Grossel,
Aye.
Representative Hassan, Representative Herr, Representative Johnson,
Yes.
Representative Liebling, Representative Lucero,
Yes.
Representative Mariani,
No.
Representative Noor,
No.
Representative O'Neill, Representative Robbins,
Aye.
Representative Zhang,
No.
Representative Considine,
I'm going to pass.
So it should be 7-6 that it prevails. It should be. Oh, you crossed that out. Okay. The amendment fails 8-5.
8-5.
No.
I don't know.
No.
It's 7-6.
It's
Mr. Chair.
7-6, it prevails.
7-6, that's what I have.
You want to recheck your numbers?
Yeah.
Huh? We'll call the roll again. Chair votes aye.
Okay, Representative Mueller,
No.
Representative Scott,
Aye.
Representative Barr,
Aye.
Representative Cantrell,
No.
Representative Carlson,
No.
Representative Considine,
Pass.
Representative Grossel,
Aye.
Representative Hassan, Representative Herr, Representative Johnson,
Yes.
Representative Lucero,
Yes.
Representative Mariani,
No.
Representative Noor,
No.
Representative O'Neill, Representative Robbins,
Aye.
Representative Zhang.
No.
The amendment prevails on a 7-6 vote. Representative Long, this is kind of a bigger data issue that this committee cares about quite a bit. We can have a more conversation about this with respect to what happens with the other omnibus bill. But the intention at the end of the day is that this will be laid over as well. It's not that that has zero effect. It does have, an effect long-term with respect to how that other omnibus bill fares, but we can have a longer conversation about it, see how we can tweak it to alleviate some concerns. Representative Barr, any other comments?
No, Mr. Chair.
Okay, and then these are crossed off, so. Okay. Is there anyone else who wants to speak to House File 2681 as amended? Chair Scott.
Thank you, Mr. Chair. I think my name was on the list prior to, I don't know, maybe it didn't get on there, but I had a couple of questions for the co-ops and the munis.
Go ahead. They'll come forward as they
Okay.
ask from Chair Scott.
So to the co-ops and the munis, would creating, especially the smaller co-ops and the munis are pretty small anyway, usually, to those folks, if they're having to create these databases and so forth, is that going to be reflected on rates eventually as a cost to the businesses? Could that be transferred to customers?
Mr. Chair,
Sorry, Mr. Sulam.
Representative Scott, I think the answer is maybe potentially a little bit of both. The bill does provide that the requesting party can be held to pay the cost. but there may be some basic things, some structural things that aren't related to a specific request that would have to be done in order to meet the requests if the exemption were not to stand. And those types of extras would have to be charged back through rates. It's the only way we have of generating revenues. But individual requests, the time and the copies would be paid by the requesting party under the bill.
Chair Scott?
I was going to ask the same question of Ms. Peppin.
Ms. Peppin, go ahead.
Thank you, Mr. Chair and Representative Scott. I think there is definitely a potential, especially when you consider subdivision 6, if the amendment didn't sustain, because of the data security and privacy section. The potential of cybersecurity risks is so great that I think that each co-op would have to look at their staffing levels. And of course, as you know, some of the smaller co-ops might have 14, 15, 16 employees, and most of them are line workers. So to be able to ensure this, or alternatively to have to contract it out to another third party, is definitely going to have a cost. And as you know, we work for our consumer owners, and we do everything possible to keep rates low, but this certainly has the potential to have an impact.
Thank you. And Mr. Chair, just a couple of comments about the bill, and because we are the committee that looks at all these data issues, and some of my concerns, in addition to what was already been mentioned here, is my concern is that eventually with the collection of all this data, if there ever comes a time when there's any concern or any parameters put around energy usage itself, is that with this data, our thermostats could eventually be regulated by electronic means, because somebody arbitrarily or by law that may eventually come, and of course, hopefully it would come through this body, but if somebody says you can only use so much energy per household or per business, then having this data at someone's fingertips could, I think, be kind of dangerous. And I do have one of the things that I hadn't considered with this bill, but former Representative Peppin brought up, was that through connecting the dots, a hacker could figure out when someone is home. If someone goes south for the winter, they could determine that based on energy usage that person is not at their home, and it could be a problem there as far as someone breaking into the home. So that's something I hadn't thought about, and I understand what the bill author's trying to get at here, but I just have a lot of concerns with what this really means to the customer as a whole. Thank you.
Okay, thanks. If there are no other questions,
Mr. Chair,
we're
there
going
is.
to lay the bill over.
Before that, we'd like to have another vote on the amendment, please. We had members arrive that we feel that might change that vote.
No. That's not in order.
Mr. Chair, that's not in order.
I correct that how that was phrased was not in order. Would you care to rephrase your motion?
Yeah, what are the words I'm looking for? Reconsider the amendments, Mr. Chair.
Okay, motion has been made to reconsider the A1 amendment. All in favor, say aye.
Aye.
All opposed, say no.
No.
The motion prevails. So the A1 amendment is on the table, or before us, I should say. And
Mr.
is
Chair,
there
I'd
any
request a
discussion?
roll call again.
Roll call's been requested. All in favor?
Roll call.
Oh, yeah. Chair votes aye.
Representative Mueller,
No.
Representative Scott,
Aye.
Representative Barr,
Aye.
Representative Cantrell,
No.
Representative Carlson,
No.
Representative Considine,
Mr. Chair,
We're in the middle of a roll call. There's Scott.
Representative Carlson was not on the prevailing side in order to ask for
They're
reconsideration.
in the middle of a roll call. Chair Scott, go ahead.
Representative Considine, Representative Grossel,
Aye.
Representative Hassan,
No.
Representative Herr, Representative Johnson,
Yes.
Representative Lucero,
Yes.
Representative Mariani,
No.
Representative Noor,
No.
Representative O'Neill, Representative Robbins,
Aye.
Representative Zhang.
No.
The motion, are you sure? Okay. The motion does not prevail on a 7 to 8 vote. Well, if it's 7 to 7 or 7 to 8? You go to 7 to 7 or 7 to 8, it still fails. So the motion fails. Okay, seeing there being no other discussion, the House File 2681 is laid over. Thank you, Representative Long. Members, we got through 6 bills in 2.5 hours. And we'll be reconvening tonight 15 minutes after session to complete the rest of the agenda. And that will happen in 500 North. We'll try to get a better room, but as of right now, it's going to be 500 North. Judiciary is in recess.